Kwa sasa inang'oa nanga na ambapo kuanzia sasa hadi mwendo wa saa 7:30 nitakuwa na kufahamisha mengi ikiwemo matukio ambayo yanajiri katika maeneo tofauti humu nchini Kenya, huku tukiungana na waandishi wetu tayari kutujuza ni kipi ambacho kinajiri. Kumbuka leo ikiwa ni siku ya Jumanne, ikiwa ni tarehe 28 mwezi Novemba mwaka 2023. Asante sana kwa kujiunga nasi katika awamu hii. Mimi ni mtangazaji wako Paul Kirobi. Tuna mengi ambayo tumekuandalia mchana wa leo, lakini kwanza kabisa tuangazie tu baadhi ya taarifa ambazo tutakuwa tunazidi kufuatilia kwa kina zaidi, kisha tukujuze mengi zaidi mwendo wa baadaye. Kwanza kabisa kwenye taarifa ya kwanza ni kuhusiana na utata wa matokeo ya mtihani ya kitaifa KCPE, ambapo walimu, wazazi na wanafunzi waliowasilisha kesi dhidi ya NEC watakuwa nasubiri uamuzi wa mahakama. Ni shughuli ambayo inaendelea sasa hivi katika mahakama kuu, na mahakama kuu inatarajiwa kutoa uamuzi wake kuhusu sheria tata ya fedha mwaka 2023, swala ambalo lilikuwa limekumbwa na utata katika mahakama. Na mbali na taarifa hiyo, taarifa nyingine ni kuhusiana na hasara ya mafuriko, ambapo mafuriko yanaendelea kusababisha maafa kote nchini, ambapo zaidi ya watu 70 wamefariki kufikia sasa. Taarifa ambayo tutakuwa tunatathmini hali iko namna gani katika kaunti mbalimbali, na kisha baadaye kukujuza mengi zaidi mwendo wa jioni. Mbali na taarifa hizo, mtazamaji, itakuwa nimefanya vibaya iwapo nitakosa kukufunza mawili matatu kuhusu maisha ya kila siku.
Methali ya leo: jamaa yenye mabishano hula ugali mbichi.
Maana ya nje: wapiganao wakati wa mapishi hushindwa kufahamu chakula kilichoiva, hivyo hula kikiwa kibichi.
Maana ya ndani ya methali hii ni kwamba wagombanao hawanyokewi na mambo.
Matumizi: hurejelea watu waliokosa kufanikiwa kutokana na ugomvi kati yao.
Matumaini yangu mtazamaji umejifunza mawili matatu kuhusiana na maisha ya kila siku, kwamba wagombanao hawanyokewi na mambo. Kwa sasa tunang'oa nanga, ambapo mahakama ya juu asubuhi ya leo inapaniwa kutoa uamuzi kuhusu malalamishi ya kupinga sheria ya fedha ya mwaka 2023 hapa jijini Nairobi, ambapo majaji David Majanja, Christine Meoli na Lawrence Mugambi kwa sasa wanaendelea kutoa uamuzi kuhusu maombi hayo. Malalamishi mbalimbali yaliwasilishwa kupinga sheria hiyo iliyoanza kutumika tarehe 1 mwezi Julai, kabla ya Jaji Mugure Thande kutoa maagizo ya kusimamisha utekelezaji wake. Kwa sasa wacha tuvuke katika mahakama kuu tusikilize ni kipi ambacho kinaendelea.
In Article 110 of the Constitution, hence the concurrence of the Speaker of the Senate was not required and the participation of the Senate was precluded by Article 114 of the Constitution. We have already found that the Finance Bill 2023 was a money bill within the meaning of Article 114 of the Constitution. Thus, pursuant to Article 109, sub-Article 5, it could only be introduced and considered in the National Assembly in accordance with Article 114 because it dealt with amendment of laws relating to and imposition of taxes under Article 209 of the Constitution, which is a function of the national government. The role of the Senate is expressly circumscribed by Article 96, sub-Article 2 of the Constitution, which limits its lawmaking function to considering, debating, and approving bills concerning counties as provided in Articles 109 to 113, thereby expressly excluding money bills envisaged in Article 114. Accordingly, and from a plain reading of Article 96, sub-Article 2, and Article 114 of the Constitution, the concurrence of the Speaker of the Senate was not required in respect of a money bill. In this case, the issue of concurrence of the Speaker of the Senate arose when he addressed the Speaker of the National Assembly through the letter dated 15th of June 2023, reference number, that he ascertained that the Senate had a role in the registry process pertaining to finance bill, where he stated as follows. We have provided that letter, the citation, so I'm not going to go through it. It is in the judgment. Subsequently, the Speaker of the Senate resiled from that position that he had earlier taken and affirmed that the matter did not require concurrence of the Speaker of the Senate by his letter dated 26th of June 2023, which we have also provided the quotation, or the letter is set out. No explanation was tendered as to the cause of the alleged error or on such an important question. Now considering this, the second letter. No explanation was tendered as to the cause of the alleged error on such an important question, resulting in two evidently contradictory letters issuing from the office of the Speaker of the Senate. Nonetheless, it appears that two speakers of the Parliament eventually resolved that the Finance Bill 2023 was a money bill. This determination is not binding on this court, which has jurisdiction to interrogate the legality of the position taken by the speakers. A money bill is distinct, being neither special or ordinary bill concerning counties. Thus, it is not subject to the procedure in Articles 110 to 120 of the Constitution, requiring concurrence of two speakers as a condition precedent and or involvement of the Senate, as was held in Pevan's East African case. That said, in this instance, the position taken by the Speaker of the Senate in his letter dated 15th of June 2023 is not idle, as the Supreme Court, in the matter of the Speaker of the Senate and another, were discussing the role of the speakers of the respective House of the Parliament, observed as follows. I think it's necessary that I read part of this. This is what the Supreme Court said. Is it in doubt, that is quote, is it in doubt, in view of the formal provisions of the law, when and how the question for the consideration of the two speakers arises under Article 110 of the Constitution? We do not think so. No, Mr. Norje submitted the requirement for a joint resolution of the question whether a money bill is one concerning counties is a mandatory one, and the legislative path is well laid out. It starts with the determination of the question by either speaker, depending on the origin of the bill. Such a determination is communicated to the other speaker with a view to obtaining concurrence. Failing a concurrence, the two speakers are to jointly resolve the question. Both sets of standing orders are crystal clear on this scenario, and both on this point, as we find, faithfully reflect the terms of the Constitution itself. It is clear, though some of the counsel appearing before us appear to overlook this, that the business of considering passing of any bill is not to be embarked upon and concluded before the two chambers, acting through their speakers, address and find an answer for a certain particular question. What is the nature of the bill in question? The two speakers, in answering that question, must settle three sub-questions before a bill that has been published goes through the motions of debate, passage, and final assent by the President. The sub-questions are, is this a bill concerning county government? And if it is it a special or an ordinary bill? Is this a bill not concerning county government? That is number B. And C, is this a money bill? How do the two speakers proceed in answering those questions or sub-questions? They must consider the content of the bill. They must reflect upon the objectives of the bill. This is by the Constitution. It's not a unilateral exercise. And on this principle, it is obvious that the Speaker of the National Assembly, by abandoning all the engagement or consultation with the Speaker of the Senate and proceeding as he did in the matter before the court, and acting contrary to the Constitution and its fundamental principles regarding harmonious motion of state institutions. Neither speaker may, to the exclusion of the other, determine the nature of a bill, for that would inevitably result in usurpations of jurisdiction to the prejudice of the constitutional principle of harmonious interplay of state institutions. It is evident that the Senate, though entrusted with less expansive legislative role than the National Assembly, stands as a constitutional safeguard for the principle of devolved government. This purpose would be negated if the Senate were to not participate in the enactment of legislation pertaining to the devolved units or the counties. Our understanding of the foregoing pronouncement of the Supreme Court is that prior to either house taking up any bill, it is desirable, and we deliberately use the word desirable, it is desirable for the speakers to determine the nature of the bill and the path it should take. From the perspective of the Supreme Court, the two speakers ought to have concurred as to the nature of the bill prior to the introduction in the National Assembly. In any event, as already stated, the concurrence of the two speakers of Parliament cannot oust the jurisdiction of the court under Article 165 of the Constitution to interrogate such concurrence. We have a case here, the case of the Institute of Social Accountability, and another was the National Assembly, which stresses that fact. Having held that the Finance Act is a money bill, we are not persuaded that the failure by the Speaker of the National Assembly to seek concurrence from the Speaker of the Senate prior to the introduction of the Finance Bill vitiates the Resources Act. Concurrence of the two speakers is not a requirement, under Article 114 of the Constitution.
Over to Justice Meoli, the next part.
Thank you, Judge. I will deal with two issues. That is issue number 2 and 3. Issue number 2 being whether the public participation conducted was sufficient. Issue number 3 being whether certain taxes cited in the petition and as enacted by the Finance Act are unconstitutional. Starting with the issue number 2, whether the public participation conducted was sufficient. The petitioners assailed the Finance Act on the ground that there was inadequate public participation. We appreciate that public participation is a hallmark of constitutional democracy and a manifestation of the people's sovereignty. Article 10, Sub-Article 2A of the Constitution affirms public participation as part of the national values and principles of governance that must guide all persons, state organs, state officers, and public officers when making or implementing public policy decisions. Moreover, Article 118 provides for the participation by the people in the legislative process, and we cited that provision. The principle of public participation in the lawmaking process has been considered in many judicial decisions. The Supreme Court, in the matter of the National Land Commission, acknowledged the principle of public participation as a form of checks and balances on the various arms of government in the execution of their mandates. In British American Tobacco PLC, the Court of Appeal set out the principles of public participation. I will just cite a few of them. The first being, it applies to all aspects of governance, and number 2, the public officer and or entity charged with the performance of a particular duty bears the honors of ensuring and facilitating public participation. Number 3, the lack of a prescribed legal framework for public participation is no excuse for not conducting public participation. Number 4, public participation must be real and not illusory. Number 5, public participation is not an abstract notion. It must be purposive and meaningful. Number 6, public participation must be accompanied by reasonable notice and reasonable opportunity. Number 7, public participation is not necessarily a process consisting of oral hearings. Written submissions can also be made. And the court went further to outline the components of meaningful public participation, which you have cited there. Whether the public participation exercise was sufficient to meet the test in the BAT case is a question of fact. There is ample evidence that the National Assembly invited citizens to submit and give comments on the bill by way of letters to various stakeholders and newspaper advertisements. Secondly, the invitations indicated the venues of the public meetings and the manner of submission of written memoranda on the bill. The National Assembly provided liaison officers for the meetings. We find that the manner in which the National Assembly proposed to conduct the public participation was not only facilitative but also reasonable in the circumstances. Further, we do find that the public participation exercise was real and not illusory or cosmetic because, in response to the invitations, various members of the public and stakeholders gave their views and comments, which were received by the committee. From the matrix of stakeholder comments and memoranda exhibited by the respondents, the views of the stakeholders and members of the public were considered, as some proposals were adopted while others were rejected. The public participation exercise was thus real and gave diverse stakeholders an opportunity to present their views on the bill. The petitioners complained that some of the submissions by the members of the public were rejected without giving reasons. The enactment of the Finance Act is a legislative process, and in discharge of its legislative mandate, the National Assembly passed it. There is no express obligation on the part of Parliament to give written reasons for adopting or rejecting any proposals received from members of the public. Nevertheless, we think that in order to enhance accountability and transparency, it is desirable that the relevant committee, after conducting public participation, gives reasons for rejecting or adopting proposals received. Apart from the sufficiency of public participation, the petitioners complained that the National Assembly incorporated into the bill 18 additional amendments whose proposals were not subject to public participation. The proposed amendments were to the Income Tax Act, the Value Added Tax Act, the Excise Duty Act, and Miscellaneous Fees and Levies Act, the Kenya Revenue Authority Act, the Retirement Benefits Act, the Alcoholic Drinks Control Act of 2010, the Special Economic Zones Act, and the Export Processing Zones Act. The National Assembly Standing Orders 132 and 133 permit amendments to be made to a bill during the committee stage. And we have cited again the case of Pevans, East Africa, the decision of the Court of Appeal in that matter, where the court affirmed the position that Parliament has a power during the legislative process to make changes to a bill post-public participation. And I think it's important that I read this passage. It must be appreciated that after the National Assembly has heard the views of members of public and industry stakeholders on a bill, it is not precluded from effecting amendments to the bill before finally passing it. These amendments do not necessarily have to agree with the views expressed by the people who have been heard, so long as the views have been taken into account. In our view, it would bring the legislative process to a complete halt and undermine Parliament's ability to discharge its constitutional mandate if, after having facilitated public participation on a bill, Parliament is required to adjourn its proceedings every time a member proposes an amendment to the bill so that further public participation can take place on the particular proposed amendment. End of quote. By its nature, public participation is intended to explore new issues that may be raised, interrogate, and understand existing ones, which may lead to revision or refinement of the bill through new proposals and amendments. We are bound by the holding in Pevans case, which I have read from, that once the National Assembly has heard the views of the general public and the stakeholders on the bill, it is not precluded from effecting amendments to the bill during debate before it is passed, as a contrary position would amount to curtailing the legislative mandate of the National Assembly. The National Assembly was not required, therefore, to submit the amendments complained of to public participation on narrow issues that were within what was contemplated within the objects and memorandum of the bill. Having considered the relevant facts and the record, and bearing in mind that the Finance Bill is a time-bound legislation, we are satisfied that the public participation process conducted by the National Assembly was sufficient. I will now move to the third issue, which is whether certain taxes cited in the, whether certain taxes cited in the petition as enacted by the Finance Act are unconstitutional. The petitioners challenge tax-raising measures introduced by the Finance Act. We will resolve them in light of the applicable constitutional provisions. Under Article 94, Sub-Article 1 of the Constitution, the legislative authority of the Republic is derived from the people and vested in Parliament. Correspondingly, Article 210, Sub-Article 1, provides that no tax or licensing fee may be imposed, waived, or varied except as provided by legislation. The power to impose taxes by the national government is provided for in Article 209 of the Constitution, and we have cited the entire provision. And the totality of the aforesaid provisions is that the legislature, in this case the National Assembly, has broad powers to levy tax, so long as the power is not exercised in a manner that infringes or violates provisions of the Constitution, more particularly the process prescribed under the Bill of Rights. Tax laws are not enacted in a vacuum. They're the product of a process which is recognized by the Constitution. Upon formulation of policies underpinning the revenue and expenditure by government, the legal process commences with the National Treasury preparing a budget policy statement and submitting it to the Cabinet for approval pursuant to the Public Finance Management Act. This culminates in presentation of the estimates of revenue and estimates of expenditure and the budget to the National Assembly for consideration and enactment of the Appropriations Act under Article 220 and 221 of the Constitution. Revenue-raising measures are provided for in the Finance Act, which is a money bill recognized by Article 114 of the Constitution. In view of the merger of policy and legislation, as reflected in many judicial discretions, courts have been slow to interfere with tax legislation. We cite here the case of in the state of MP versus Rakesh Kohli and another. It's a decision of the Supreme Court of India. It's a brief one, I'll just read for us. While dealing with the constitutional validity of a taxation law enacted by Parliament or state legislature, the court must have regard to the following principles. 1, there is always a presumption in favor of constitutionality of a law made by Parliament or a state legislature. 2, no enactment can be struck down by just saying that it is arbitrary or unreasonable or irrational, but some constitutional infirmity has to be found. 3, the court is not concerned with the wisdom or lack of it, the justice or injustice of the law, as the Parliament and state legislatures are supposed to be alive to the needs of the people whom they represent, and they are the best judge of the community by whose suffrage they came into existence. 4, hardship is not relevant in pronouncing on the constitutional validity of a fiscal statute or economic law. And 5, in the field of taxation, the legislature enjoys greater latitude for classification. The respondents argued that the court should not intervene in tax issues because these are policy matters. This approach is correct to a certain extent, as exemplified by Odunga J. in Wawero and 3 others, versus the National Assembly. I do not need to read that, but we have cited the passage from his judgment. On the other hand, the court has a constitutional duty under Article 165, Subarticle 3b, D, and D, Roman 1 and 2, to determine the question whether a right of fundamental freedom in the Bill of Rights excuse me, has been denied, violated, infringed, or threatened, and whether any law is inconsistent with or in contravention of the Constitution. And the question whether anything said to be done, excuse me, to be done under the authority of this Constitution or any other law is inconsistent with or in contravention of the Constitution. By these provisions, neither laws nor policies are immune from the scrutiny of the court. And in the Nubian Rights Forum, and 2 others versus the Attorney General, the court echoed this position by stating that anything done by Parliament outside the confines of the Constitution and the law attracts the attention and action of this court. In conducting an inquiry into the constitutionality of the decisions and actions of the legislature, the court finds constitutional authority in Article 165, 3d. The thrust of the respondent's response to the petitioner's case is that the legislature has the power and authority to impose taxes. This power is not unconstrained. It is constrained within the 4 corners of the Constitution. Parliament cannot exercise its power in an arbitrary fashion without any rational connection to a legitimate purpose. To permit the legislature to assert a contrary position would undermine the national values of and principles of the rule of law, good governance, accountability, and transparency. Turning now to the taxes challenged, the petitioners attacked Section 2, as read with Section 21 of the Finance Act, for amending Section 35 of the Income Tax Act as unconstitutional for imposing taxes on entertainment, which is a function of the county government under Part 2.4 of the 4th schedule of the Constitution. Digital monetization is introduced in Section 2 as a tax on payments for entertainment, social, literal, etc., through any medium or channel. Such payment is treated as income, and a person paying a non-resident or a person not having a permanent establishment is required to pay withholding tax on the payment. The purpose of the amendment here is to clarify the type of income to be taxed. It is a tax on income which the national government is authorized to impose pursuant to Article 209(1) Subarticle A of the Constitution. This does not affect the powers and functions of the county governments as contended by the petitioners. Similarly, digital asset tax introduced by Section 2 is payable by a person on income derived from the transfer or exchange of digital assets, for example, cryptocurrency. This is a tax on income, and the manner in which it is charged and collected is within the purview of Article 209, Subarticle 1A of the Constitution. The petitioners also challenged the Finance Act on the ground that it includes tax on winnings from betting, gaming, and lotteries, which they contend violates the 4th Schedule, Part 2 of the 4th Schedule of the Constitution, in that betting, casinos, gambling, and gambling fall within the powers and functions of the county government. The Finance Act amends Section 2 of the Income Tax Act to define winnings as a payout from a betting, gaming, lottery, prize competition, gambling, or similar transaction under the Betting, Lotteries, and Gaming Act, excluding the amount staked or wagered in that transaction. This section is to be read with Section 10 of the Income Tax Act, Section 10 of the Income Tax Act, which states that winnings constitute income accrued in or derived from Kenya and are subject to income tax. The purpose of this amendment, to our view, was to clarify the definition of the term winnings. This is plainly income, a matter of income within Article 209, Subarticle 1A, and does not affect the powers and functions of the county governments, as was held in Pevan's case. The petitioner, in Petition E211 of 2023, challenged the proposal in the Finance Bill seeking to raise the entry point of eligibility of businesses for payment of gross turnover tax from a sum of 1 million shillings to Kenya shillings 500,000. Upon our perusal of the Finance Act, we found that this proposed amendment was not enacted. Section 26 of the Finance Act amended the 3rd Schedule of the Income Tax Act to introduce new tax bands. In addition, Section 7 of the Act amended Section 10 of the Income Tax Act relating to withholding tax. The petitioners have not demonstrated how these amendments affect specific provisions of the Constitution. In any event, we hold that these are matters related to tax policy and administration. Section 33 of the Finance Act amended Section 17 of the VAT Act to introduce 16% VAT on insurance compensation. The petitioners argued that insurance compensation is not income and is therefore not subject to taxation, and further that the provision amounts to expropriation of property in violation of Article 40 of the Constitution. We hold that imposition and collection of tax by legislation does not of itself constitute a violation of the right to hold or own property, and here we cite the case of George Lesaloi Selelo and another versus the Commissioner General. This amendment, the amendment that is by Section 33, only applies to persons who had claimed input VAT on supplies or services and who subsequently receive compensation, which includes VAT, and are therefore required by the amendment to declare the VAT component. This, too, is a tax administrative measure and does not violate Article 40 of the Constitution. The petitioners equally challenged Part 2, that is Sections 30 to 38 of the Finance Act, which amended Sections 5, 8, 12, 17, 31, 34, 43, the 1st and 2nd Schedule of the VAT Act. These provisions impose, vary, or remove VAT on specific goods and services. They also vary the VAT rates applicable and the manner VAT is administered. We hold that these are matters within the competence of the legislature and reflect the policy choices of the national government. And the petitioners, to our mind, have not shown how these provisions violate the Constitution. Moving on to Part 4 of the Finance Act, which contains Section 40 to 48, which introduced amendments to Section 2, 20, 28, 40, the first and second schedules, and added Sections 36(1)(a) and 36(a) to the Excise Duty Act. We say that excise duty is a tax on the sale and importation of specific goods and services. The amendments introduced the requirement for remittance of excise duty on betting and gaming within 24 hours of closure of a transaction, as well as remittance of excise duty on alcoholic beverages within 24 hours of removal of the goods from the stockroom. The petitioner's complaint is that the requirement is unreasonable. We find that this is a tax administration measure designed to ensure that excise duty is collected and accounted for. We do not find any justification to intervene in that matter. Other grounds upon which the respondents assailed the excise duty relate to changes in tariff headings and rates of taxation on various products. The petitioners have not shown how these provisions violate the Constitution. We therefore hold that these changes are governed by policy and do not violate the Constitution. The petitioner in petition E211 of 2023 challenged excise duty imposed on human hair, wigs, false beards, eyebrows, eyelashes, and artificial nails in respect of the finance bill. You can see I'm smiling. However, this provision did not see the light of day and was not enacted into the Finance Act and is therefore a non-issue. Thank you.
I shall now read the second last issue, which is whether the Section 84 of the Finance Act 2023, introducing the housing levy, is unconstitutional. The petitioner's grievances against the introduction of the housing levy are varied and include the following: that gross salaries of employees will be impacted, that salaries of judges, members of constitutional commissions, and holders of independent offices will be affected in contravention of the Constitution, that there was a lack of a legal framework on the imposition and administration of the levy, contrary to Article 210, that the absence of a foundational statute results in uncertainty, that no fund as envisaged in Article 2061 has been put in place, and the Constitution places an obligation on the national government to deposit all monies it raises in taxes in the consolidated fund, that KRA's mandate does not include collection of funds arising from the levy, that the provision violates the Housing Act, and that it further violates that the deduction is unconscionable and impractical, that Part 1 of the 4th schedule to the Constitution limits national government's functions in relation to matters housing, to development of a housing policy, and no more, that public participation in respect of the levy was cosmetic and a mockery of the centrality of the people as a source of authority exercised by the government, that the Employment Act already obligates employers to provide housing for the employees, and that the imposition of the levy amounts to double taxation and is a form of regressive and discriminatory tax that imposes a disproportionate burden on one group of earners without justification, and is therefore a violation of Articles 10, 21.3, 27.3, 201 of the Constitution, that the imposition of the tax under the Employment Act, whose right is to secure rights of employees, amounts to a limitation of labor rights, amongst others, and must be justifiable under Article 24 of the Constitution. The respondent's answer to the petitioner's grievances is that the taxation is a prerogative of the national government, that the national government is not seeking to regulate income as a socio-economic activity, but the amendment is aimed at taxation on income, which the national government is empowered to impose, and that establishment of a housing fund is a policy decision aimed at enabling the government to provide adequate housing for all its citizens towards fulfilling the dictates of Article 43(1)(b) of the Constitution. They further argue that the impugned section enjoys presumption of constitutionality, and that the introduction of the levy is not a novel issue, as there are other levies imposed by the national government that are geared towards collecting funds for various key priority areas, such as the Sugar Development Levy, Railway Development Levy, Road Maintenance Levy, National Hospital monies paid to the National Hospital Insurance Fund, the National Social Security Fund, Hotel and Catering Levy, Fuel Levy, Standards Levy, and others. They submit that the housing levy will assist the government provide affordable housing and alleviate the housing shortage in this country. Further, the taxation targets certain sectors of the economy, and if sufficiently justified, differentiated treatment is not unconstitutional. The respondents defended the appointment of KRA as an agency of the government for collection of revenue to collect the levy, citing Section 5(1) of the KRA Act and Section 75 of the Public Finance Management Act. It was also asserted that the levy is anchored in the Housing Act and amendments to the Employment Act, and that further amendments had been conceived and were being introduced to create the housing levy fund pursuant to Article 206(2). That said, the fund would be distinct from the National Housing Development Fund created by Section 7(3) of the Housing Act, and that these provisions satisfy the prescriptions in Articles 12, 10, 201, 206, and 209 of the regarding legality of tax measures. We now turn to consider the substantial issue raised by the petitioners whether the amendment of the Employment Act by Section 84 of the Finance Act to create a housing levy or tax in accordance with was in accordance with the constitutional requirements. The effect of the amendment was to add sections 31B and 31C to the Employment Act. The amendment is in 3 parts. The first part imposes a levy on the employer and employee. The second part states that the purpose of and ring fences it, while the third part imposes on the employer the obligation to deduct, collect, and remit the levy, and provides a sanction for non-compliance, and we have set it out in full. The petitioner argued that the housing levy is not a tax contemplated under Article 209 of the Constitution. The amendment does not contain a legal definition of the housing levy, nor even define the term levy as used in that amendment. This lack of uncertainty is a matter of importance, is a matter as important as the definition of the housing levy is a major defect in the impugned amendment. One of the distinguishing features of the other existing levy that was cited by the respondents in defending the housing levy is that they are anchored in comprehensive acts of parliament that include definitions of subject levies. Other tax legislation, such as the Income Tax, VAT Act, Excise Duty Act, contain definitions of the taxes imposed therein. The petitioners also pointed out that the definition of employee contained in the amendment does not distinguish between local and foreign employees. Although the Constitution does not use the term levy, a levy is for all intents and purposes a form of tax. According to Black's Law Dictionary, a levy is the imposition of a fine or a tax, the fine or tax imposed, and to impose or assess a tax or fine by a legal authority. Whereas the term tax means a charge, usually monetary, imposed by the government on persons, entities, transactions, or property to yield public revenue. Broadly, this term embraces all government impositions on the person, property, privileges, occupations, and enjoyment of the person, and includes duties, imposts, and excise. The petitioner argued that the levy is not one of the enumerated taxes in Article 209 A, B, and D of the Constitution. In the absence of a clear definition of a levy within a foundational statutory enactment, it is difficult to confidently associate a levy with the category of taxes envisaged in the foregoing provisions, although on the face of the amendments it is intended to be levied on income of employees. The uncertainty surrounding the housing levy is compounded by the failure to state the nature of the tax, percentage payable by the employer, is it income tax or a contribution paid by the employer for the benefit of an employee. Under Article 209(2), an Act of Parliament may authorize the national government to impose any other tax or duty except those which the county may impose, which include property rates, entertainment taxes, or any other tax it is authorized to impose by an Act of Parliament. Related to this issue is the question whether imposition of the housing levy is a matter concerning county governments. The petitioners argued that housing development and planning is a function of the county governments under Part 2 of the 4th Schedule. The respondents contend that the levy is part of the housing development policy and Part 1 of the 4th Schedule of the Constitution to support affordable housing. The housing levies are enacted by the Finance Act by way of an amendment to the Employment Act to support the national government policy on affordable housing. It is a tax on income duly authorized by Article 209(2) of the Constitution. Related to this issue is whether that imposition is a matter concerning county governments. as argued by the petitioners. The housing development and planning is a function of the county government under Part 2 of the 4th schedule of the Constitution, while the respondents contend that it is underpinned by the power and function of the national government under Part 1 of the 4th schedule to support affordable housing. The 4th schedule provides the distribution of functions between the national government and the county governments. Part 1(2) of the 4th schedule grants the national government authority over housing policy, while Part 2(8) of the same schedule provides for county planning and development of housing. Lenaola J. explained the distinction in the housing function between the two levels of government in Law Society of Kenya versus Cabinet Secretary, Ministry of Lands, Housing and Urban Development. He stated that the words housing policy and housing as used in the 4th schedule in respect of the national and county government functions respectively are capable of varied interpretation and application. Black's Law Dictionary defines a house as a home, dwelling or residence, while policy is defined as general principles by which a government is guided in its management of public affairs. A mandate of the national government involves accreditation, regulation, and promotion of quality assurance, technical capacity assistance in the construction industry at large, while the county government is involved in housing to the extent of planning and development within a county only, and there are also other cases we have cited. The distinction between the housing functions between the national government and county government was also considered by the Court of Appeal in Speaker of the National Assembly and others versus Senate and others. The question in that case was whether contributions to the National Housing Development Fund infringed county government functions, and this is what the Court of Appeal stated. An examination of the Act indicates that notwithstanding the amendments are housing related, the central theme is to establish a National Housing Development Fund into which employer and employee contributions are to be paid, the sums which go towards financing the building of affordable units. Insofar as the enactments concern the imposition of taxes under 209 of the Constitution, which are paid into the National Housing Development Fund, we find the national perspective upon which the housing development policy is founded is not a county function to which Article 103 of the Constitution required to be applied. We agree that housing is a shared responsibility between the national and county governments, where each level of government has a defined role to play. In this case, the purpose of the levy, as stated in the amendment, is to provide funds for the development of affordable housing and associated social and physical infrastructure, as well as provision of affordable home financing to Kenyans. In this case, therefore, the stated purpose of the levy is to support the national policy on housing, and we find that the petitioners have not demonstrated how this policy interferes with the functions of the county government under Part 2 of the 4th schedules. Legal certainty is one of the hallmarks of the rule of law, good governance, transparency, and accountability under Article 10, 2A, B, A, and C of the Constitution. The amendment, in our view, does not, either on its face or by reference to other legislation, show how the stated purpose is to be achieved. It is not open to the respondents to supply these details through responses, as they have not sought to do. As they have sought to do. The enactment ought to address these details and speak for itself. Article 210 contemplates a comprehensive taxation law, without which it is virtually impossible to determine whether and how the imposition of the levy will impact the shared function of housing, or whether it will restrict or limit the functions and powers of county government under Part 2 of the 4th schedule, which raises the further issue whether Parliament, as used in 209(2) and 209(3)(c), refers to both houses of Parliament, and whether the Senate ought to have been involved in deliberations relating to that amendment. This is yet another lacuna that the amendment did not address in its definition, resulting in uncertainty. The petitioners challenged the housing levy on ground that it was enacted as an amendment to the Employment Act without a comprehensive legal framework to govern it, in violation of Article 210, national values and principles of governance, in Articles 10, 2A and C, namely rule of law, good governance, and transparency and accountability. They submitted that There is no legal framework for administration of the housing levy despite the imposition and collection of the levy. They faulted the appointment of KRA as an agent of collection of the levy on the ground that it contravenes Section 5(1) of the Kenya Revenue Authority Act and the first schedule thereto, and hence it is of no legal effect. They contended that without a comprehensive legal framework being put in place, the national government would threaten, undermine, or usurp the functions of county government. That without such a comprehensive legal framework, there would be no guarantees that the functions of county government specified in the constitutions will be respected. The respondents' rebuttals were somewhat mixed. On the one hand, they stated that the housing levy is anchored in the Housing Act, which established the National Housing Development Fund, and in the Employment Act as amended. That an amendment was in the pipeline to anchor the levy and create a fund separate from the Housing Development Fund in the Housing Act in compliance with Article 261. They further asserted that it is the prerogative of the national government to impose taxes aimed at enabling the government to provide adequate housing for all citizens towards fulfilling the right to accessible and adequate housing and to reasonable standards of sanitation provided under Article 43(1)(b) of the Constitution. They reiterated the creation of the housing levy is not novel, as there are other levies by the national government that are geared towards collecting funds for various key priority areas. On the issue of collection of the housing levy, KRA pointed out that under Section 5 of the KRA Act is an agent of the government for purposes of receipt of the national revenue and was duly appointed as such. That under Section 75 of the Public Finance Management Act, KRA is mandated to collect the revenue for the national government. Article 210 provides that no tax or licensing fee may be imposed, waived, or varied except by provided by legislation. In addition, Article 110(2)(b) and C outlines the national values and principles of governance and has the components of rule of law, good governance, transparency, and accountability, amongst others. The gravamen of the petitioner's case is the housing levy introduced through an amendment of the Employment Act by Section 74 has a number of shortcomings that in our view fall short of the principles of legal certainty, rule of law, good governance, as well as transparency and accountability. Although Section 84(3) of the Finance Act says that the housing levy shall not be used for any other purpose other than development of affordable housing, associated social, physical infrastructure, as well as provision of affordable home financing to Kenyans. It is not anchored by a corresponding legal mechanism demonstrating how this objective has been actualized. These, unlike other levies cited by the respondents, which are collected for a specific purpose and are anchored through a legal framework governing them, Section 84 does not set out how this levy will be administered once it's collected. More importantly, the legislation does not set how it supports the housing policy function of the government. This concern is not idle, as the manner in which money is administered and spent may encroach on the powers and functions of county government. Further, without a framework embedded in legislation, how would members of the public know who are the beneficiaries of the housing levy? What are the requirements for one to benefit? The opaqueness undermines transparency and accountability, and in our view, Section 84 of the Finance Act does not meet the good governance test required under Article 10(2)(a) and C of the Constitution in the absence of a clear-cut legal framework concerning administration of these funds. In their submissions, the respondents contend that money collected as housing levy is ring-fenced by the purpose stated under Section 84 of the Finance Act, and that the legal framework supporting the housing levy is provided by the existing National Housing Development Fund established under the Housing Fund. An ex facie examination of Section 84 of the Finance Act does not in any way show any connection between the housing levy and the National Housing Development Fund. Our concern is that under Article 206 of the Constitution, all money is raised or received by or on behalf of the national government must be paid into the consolidated fund, except money that is set out in Article 206(1), which is money that is reasonably excluded from the fund by an act of parliament and payable into another public fund established for a specific purpose, and money that may, under an act of parliament, be retained by the state organ that received it for purposes of defraying expenses of that state organ. Our understanding of 206(1)(a) that money earmarked and collected for a purpose must be paid over into a public fund established for that purpose by legislation. The housing levy cannot be paid over to a fund unless there is a legislative provision connecting the levy to the fund. Such a provision does not exist in Section 84 of the Finance Act. Similarly, Section 7 of the Housing Act establishing the National Housing Development Fund does not reference the housing levy as a source of funding. Section 7.3 of the Housing Act provides that, in part, that there shall be paid into the corporation and carried into the National Development Fund all monies as may from time to time be voted or appropriated by the Parliament for payment into the National Housing Development Fund. There is no requirement that the monies collected by the housing levy are ring-fenced for the Housing Development Fund or any other fund. Ring-fencing of stand by stating their purpose is of itself insufficient to underpin a legal framework for the intended purpose, contrary to the principles of public finance in Article 201 of the Constitution. The petition has also faulted the appointment of KRA to collect the housing levy. KRA issued a notice in the local newspaper stating in part as follows: Kenya Revenue Authority would like to inform members of the public that the Cabinet Secretary, Ministry of Lands, Public Works, Housing and Urban Development, through a public notice dated 3rd August 2023, has appointed Kenya Revenue Authority as the agent for affordable housing levies. The petitioner's case is that KRA lacks legal authority under the KRA Act or any other legislation to collect levy. Under Section 5 of the KRA Act, provides the functions for the authority, and I set them out, and one of them is in performance. First, it is that the authority, under the general supervision of the minister, shall be an agency of government for collection of revenue, collections and receipt of all revenue, that in performance of its functions, the authority shall administer and enforce all provisions of written law set out in Part 1 of the first schedule for that purpose to assess, collect and account for all revenues in accordance with those laws. And then 2, provisions of written law set out in Part 2 relating to revenue, and for that purpose assess, collect and account for all the revenues in accordance with those laws. And then it also states that the minister may, by notice in the Gazette, amend the first schedule. The import of the foresaid provisions in the KRA is that KRA is empowered to collect taxes under specific legislation set out in Part 1 and 2 of the first schedule. Under that act, the minister means the minister for the time being responsible for finance. What is clear from the reading of this provision is that the housing levy is not one of the taxes KRA is empowered to collect under Part 1 and 2 of the first schedule. Further, it is the minister or Cabinet Secretary for Finance who is permitted to amend the schedule to authorize KRA to collect a specific tax. The notice issued by KRA informing the public that it has been appointed by the Cabinet Secretary, Ministry of Lands, Public Works, Housing and Urban Development to collect the housing levy does not have any legal basis under the KRA Act. We have also looked at the Public Finance Management Act, which permits the Cabinet Secretary, in this case the Cabinet Secretary responsible for finance, to designate in writing persons as receivers of government revenue. It is therefore not possible for the Cabinet Secretary for Ministry of Lands, Public Works, Housing and Urban Development to authorize collection of a levy which, as we have held, constitutes a tax under Article 209 of the Constitution. We therefore reject the argument by KRA that it is entitled to collect housing levy merely on the ground that it is entitled to charge a commission on the amount it collects in accordance with Section 1610BA of the KRA Act. The authority to collect taxes must be issued by the Cabinet Secretary for Finance. As we have shown, the framework for the housing levy legislated by Section 54 does not meet the requirements of good governance, transparency, accountability as required by Articles 10(2)A and C of the Constitution. We must point out, though, that this court does not purport to prescribe any form of legal framework to be adopted by the national government, as this is a matter within its mandate. Our concern is that the legislation imposes the housing levy and sets its purpose and no more. How does an objective observer determine whether the purpose has been met or that the monies have been applied for the intended purpose when the manner of achieving that purpose has not been defined? The national government is required to demonstrate a rational connection between the purpose of that legislation and the means by which it is achieved. We hold that Section 84 of the Finance Act is not the kind of legal framework contemplated by Article 10, 201, and 210 of the Constitution. The petitioners also complained that the housing levy applies to one category of the population, namely salaried workers in formal employment. They contend that this violates Article 27 of the Constitution, which protects equality and prohibits discrimination, and 201B1, which requires the tax burden to be shared fairly. They also complained that the housing levy amounts to double taxation because employees pay it in addition to income through pay-as-you-earn tax. Further, that it imposes an obligation on the employer to pay the levy despite the fact that under Article 30, Section 30, the employer is required to provide housing. The respondents countered this by stating that the county faces a serious housing deficit, which government is required to address in line with its responsibility to progressively realize the right to housing under 43B of the Constitution. Article 201 of the Constitution sets out the principles that guide aspects of public finance, and in particular, Article 201B provides that the following principles shall guide all aspects of public finance. The public finance system shall promote an equitable society, and in particular, the burden of tax shall be shared fairly, revenue raised nationally shall be shared equitably amongst the national and county governments, and expenditure shall promote equitable development of the country, including making special provision for marginalized groups and areas. Article 201B1 embraces the principle of fairness in taxation. It is acknowledged that in imposing taxes, there will be distinctions between classes of taxpayers, but the principle of fairness in taxation requires that this distinction must be justified as rationally related to a legitimate government purpose. This requirement prevents arbitrariness, which undermines the rule of law, and if distinctions are to be made, they must be a rational basis for them. We have looked at the responses by the respondents. Their key submission is that the national government enjoys the prerogative and latitude to impose taxes as a means of achieving the objective of realizing the right to housing. They did not answer why the tax falls upon employed formal workers as opposed to other taxpayers or non-taxpayers. In Okello and Nalala versus National Assembly and others, Odunga J stated that taxes need not look the same and selective taxes may be applied to different actors for different reasons, such as to address distribution and equity. Hence, the tax need not be similar to another for it to be rational and discrimination. We add that for any legislation to pass the rule of law test, it must have a rational connection to a legitimate government purpose. Otherwise, the tax legislation would be arbitrary and unconstitutional. It's therefore the duty of the state to provide a rational explanation for the manner in which the tax is involved. In absence of a rational explanation for the manner in which the housing levy was enacted, we can only conclude that the respondents took the easy path of least resistance, as taxing employees in formal employment is easier. It is also the respondents' constitutional responsibility to create a broad, efficient, fair tax system that complies with Article 201B1 of the Constitution and the taxes levied against persons in formal employment to the exclusion of all other than formal earners to support a national policy without a clear justification is discriminatory, irrational, and arbitrary in violation of 27(201)(b)(1) of the Constitution and therefore unconstitutional for those reasons. In the Court of Appeal, in Kenya Revenue Authority versus Waweru stated that explained the principle of unfair taxation under 201B as follows. On the issue as to whether the imposition of minimum tax results in unfair and contrary to Section 201, the threshold for fairness is ensuring that everyone bears their fair share of taxation and pays the correct amount, which is seen to be fair by vigorous pursuit of tax avoidance and evasion. The petitioners have assailed the housing levy on the ground that it will result in lowering salaries of judges, hence is in violation of Article 164 of the Constitution, as well as the commissioners and holders of independent offices in contravention of Article 258 of the Constitution. These provisions that protect the remuneration and benefits are intended to safeguard the independence of judges, of superior courts, commissioners, and independent officers, by insulating them from attempts by the political branches to influence them by reducing or threatening to reduce their remuneration and benefits. The petitioners have not demonstrated how the housing levy directly affects the salaries and benefits of protected officers, state officers, and how it violates Article 160 and 258 of the Constitution in that regard. Our reading of Article 210(3) of the Constitution is clear. It provides that no law can exclude or authorize exclusion of state officers from payment of tax by reason of the office of that state officer or the nature of work of that state officer. The petitioner's submission on that front also fails on the ground that the housing levy is a general tax that applies generally to all taxpayers and to us included. So having considered all the matters placed before us, we now conclude as follows, and this is what we state. The Finance Act is a money bill within the meaning of Article 114 of the Constitution. However, it contains some matters that do not fall within the purview or incidental to a money bill, although this does not change its basic character and substance as a money bill. The specific extraneous matters identified by the court pertain to amendment of the Kenya Roads Board Act 1999 through Section 76 and 78 of the Finance Act, amendments to the Unclaimed Assets Act by Section 87 of the Finance Act, and repeal of Section 21 of the Statutory Instruments Act by Sections 88 and 89 of the Finance Act. These amendments are extraneous to a money bill and are therefore unconstitutional. That under Article 220 and 221 of the Constitution, estimates of revenue and estimates of expenditure are part of the budget-making process. The estimates of revenue were included in the approved estimates contained in the Appropriation Bill and the Appropriation Act of 2023, as published in the Kenya Gazette Supplement number 87 of 15 June 2023 and 98 of 26 June 2023, respectively. We also find that the purport of Article 96(2) as read together with Article 114 is that the Senate is precluded from considering a money bill, which is only introduced in the National Assembly. However, in the matter of the Speaker, the Supreme Court held that it is necessary for the Speaker of the National Assembly to agree on the nature of the bill, any bill prior to introduction in any house. Consequently, the failure of the Speaker of the National Assembly to seek agreement with the Speaker of the Senate on the nature of the bill prior to its introduction in the National Assembly, in our view, does not vitiate the resultant act, as such concurrence is not a requirement under Article 114 of the Constitution. We find that there is ample evidence that the National Assembly conducted sufficient public participation in respect of the Finance Act. The National Assembly, having heard the views of members of the public and industry stakeholder on the bill, is not precluded from effecting amendments to the bill before passing it. There is no express obligation on Parliament to give reasons for adopting or rejecting any proposals by members of the public. Nonetheless, we think that in enhancing accountability and transparency, it is desirable that relevant committee, after conducting public participation, gives reasons for rejecting or adopting proposals received. We have looked at Section 2 and 21 of the Finance Act that amended Section 35 of the Income Tax Act to introduce digital monetization, and we find that this is a tax on income and it is permitted and it is not unconstitutional. The digital asset tax is a tax on income and it is not unconstitutional. The tax on winnings is a tax on income and it does not violate the 4th Schedule Part 2 of the Constitution, as it does not impair the functions of county government. We have also looked at Section 26 of the Finance Act that amends the 3rd Schedule of the Income Tax Act by introducing new bans, and these are matters that we do not consider unconstitutional. We've also looked at Section 33 of the VAT Act that introduces VAT on insurance compensation. We find that it does not violate Article 40 and it is not unconstitutional. We have looked at Sections 30 to 38 of the Finance Act, which amend Sections 5, 8, 12, 17, 34, 30, 34, 43, First Schedule, Second Schedule of the VAT Act, and we do not find them in violation of the Constitution. We also looked at Section 48 of the Finance Act, which amends Sections 2, 20, 28, and 14, First and Second Schedule of the Excise Duty Act, and by introducing Section 36(1)A and 36(A), and we do not find them unconstitutional. And we also have looked at the changes in tariff headings and rates under the Excise Duty Act, and we do not find them unconstitutional. And we find that the introduction of the Housing Levy amendment to Section 84 lacks a comprehensive legal framework in violation of Article 10, 201, 2010 of the Constitution. That levy against persons in formal employment to the exclusion of other non-formal income earners without justification is discriminatory and irrational and arbitrarily and in violation of Section Articles 27, 201, B1 of the Constitution. And flowing from those findings, we find as follows that, and these are our declarations, Section 76 to 78 of the Finance Act, amending Section 7 of the Roads Board Act, 87, amending Section 28 of the Unclaimed Assets Act, Section 88 and 89, repealing Section 29 of the Statutory Instruments Act, are unconstitutional, null and void. That Section 84 of the Finance Act violates Article 10, 2BC, 27 and 201 of the Constitution and is therefore null and void. That an order is granted prohibiting the respondents from collecting, charging, or otherwise the charge known as the Affordable Housing Act on the basis of the Section 84, and all prayers on the consolidated petition not specifically granted are dismissed, and this being a matter of public interest litigation, each party shall bear its own costs. And we thank all of you, all the councils who appeared before us, all the litigants who appeared before us, members of the public for keeping a keen eye on this matter, and we thank you all. It is part of your responsibility as citizens of our beloved country. Thank you. Yes.
Yes. Please to my judges, first and foremost, I wish to thank you very much on behalf of all the colleagues who are here. 160 pages of a judgment was not a mean feat, and especially the reasoning we have actually gone through. Let's not comment now, because each side is carrying some joy, others are a little bit aggrieved. But on behalf of the third and fourth respondents, allow me kindly to confirm that we are aggrieved by the findings as regards the Kenya Roads Board, Section 76 and 78, the Unclaimed Assets Act, the Statutory Instruments Act, and especially regulations thereunder, which possibly are in force today but may expire if that order is enforced, some of which are on revenue-raising measures, and Section 84 of the Finance Act, in which the housing levy has been declared unconstitutional, and a declaratory order has been made to stop the respondents from collecting the levies. Allow me to apply for a stay or a conservatory order for 45 days. In those 45 days, I urge you to suspend the operation of those particular findings in the judgment and any decree that may flow therefrom, pending the filing of a formal application under Rule 32.2 of the Mutunga Rules, as they are popularly known, and eventually under Rule 5.2b of the Court of Appeal Rules. The justification is as follows.
Could you go over that again, please?
Yes.
You're asking for?
A stay or a conservatory order for 45 days as regards the portions of the decision that has aggrieved the respondents, and in particular, it is a Kenya Roads Board, Section 76 and 78, the Unclaimed Assets Act, and the Statutory Instruments Act amendments, which have been declared unconstitutional. Also, Section 84 of the Finance Act, which has been declared unconstitutional as regards the housing levy, and an order has flowed therefrom, stopping the respondents from collecting the housing levy. So the reasons why we ask you for this is, first and foremost, especially for the housing levy, we have to make the necessary adjustments to the government procedure of taxation so that no party, no arm of government, no officer of the government is sued for contempt. Because that has been allowed as of now, while it is in the public domain that in fact the levy is being collected as we speak. There may be also irreversible loss, and especially if on appeal this section is upheld. Because the reason is that this is a consumption tax. It's money that is being spent to exactly do what the amended Act states, which is to try and put up housing for citizens. There would be actually no prejudice on the part of everybody who has paid housing levy. This is because, as the Court of Appeal observed in its ruling hearing, civil application number E304 of 2023, any party aggrieved by payment to the government of his levies can actually get rebates for overpaid taxes and levies. So those applications can be made and monies possibly will be refunded. Now, we also have another reason why we ask you for this, which is serious irreversible economic consequences in the operation of the arms of government, and especially when it comes to affordable housing. It is vitally important that this is preserved for a while as the government considers the next alternative after appeal or rectifying the law, the flaws in the law, as the court has identified. That in fact, there may be nothing wrong with the taxation itself, it's only that we do not have in place proper laws that are supposed to guide the policy. Therefore, with those remarks, I do pray that you grant a stay or a conservatory order for only 45 days, by which time the respondents will have taken a decision on how best to move, either to the Court of Appeal or to proper legislation. Thank you.
Thank you. No, we deal with the respondents first. Kenya Revenue. Please introduce your name for the record.
For the record, I'm Mr. Ochin Gaya. I appear for the Kenya Revenue Authority. My Lord, on behalf of the Kenya Revenue Authority, we'd like to seek a stay of the declaration with regard to Section 84 with regard to Housing Fund, the pronouncement, which is not in the finding but is in the body, as to Section 5.1 of the KRA Act with regard to the implementation of only laws with regard to the first and second schedule, because that pronouncement places us in a very awkward situation, because we not only collect the housing fund, but there are also other agencies. So we'll be seeking that pronouncement to be stayed. Why so? One, Kenya Revenue Authority has clearly captured in the judgment had issued a system adjustment and a public notice, and this system adjustment, those hearing from the bar, we are all aware that currently the pay is being collected together with the housing fund. That system adjustment will require time for it to be readjusted. Secondly, This judgment places a Kenya Revenue Authority at a position where it will be subject to suits for illegally collected funds, and 2, will need a stay order to prevent refund claims which shall be made. Why so? Kenya Revenue Authority finds itself in a position where it can only refund taxes under the statute. These are being declared to be outside the statute, where we will be subjected to damages suit. In that regard, we will be seeking that we be allowed to stay pending our formal instructions from the client on the best way forward. The petitioners will not be prejudiced in any manner, as rightly put by learned counsel Senior Murungara, they can't claim refund from the relevant agency, which is the Ministry of Lands. They can't claim not refund from the Ministry of Lands, but we seek from our side, we don't have a mandate and a remedy on how we shall recover these taxes, should the law finally be found to be proper. In that regard, I seek that you begin a 45-day stay with regard to Section 84 and that pronouncement with regard to KRA Act Section 51.
So, Soman?
Lordship, we will also be seeking stay by the Attorney General of the Republic for the declarations made by the court for the following reasons. Your Lordship, as relates to the declaration on the statutory instruments, it affects a plethora of regulations which we need to advise in order to comply with the very clear judgment of this court, various state agencies and government institutions on the effect that has on them. Your Lordship, as relates to Section 84 of the Finance Act, as relates to the housing levy, we need time to advise the parent ministries on any commitments or contracts they might have entered into as it relates to the collection paid under the housing levy. We understand that the court has pronounced itself. We want to comply, and we will comply with the judgment of the court, but we are seeking, in order that we don't occasion any loss to the public, we'll be given that time to be able to sort those issues out. The third one is, Your Lordship, and it's a matter alive before you, we want the 45 days, and we pray you give us the 45 days in order to save judicial time. For sure, if that stay is not given, there will be a plethora of contempt proceedings against public officers for non-compliance with your judgment. In order to avoid that, we also want to make sure that we comply and we advise them on what they need to actually do. The third issue, Your Lordship, is we'll be seeking the advice and we will be consulting. Likely this is a matter that might head to the Court of Appeal on a 5-2B, so that we also save public time. We seek to be given that opportunity to also go to the court to be able to ventilate this matter. We think it's the court, Your Lordship, this court has done this many times, especially in matters of public interest litigation, to ensure that there is no piggyback and orders are not being lifted now and then. Parties are given time to save judicial time and to also to save the time that public officers spend on these issues. We do pray humbly you give us those 45 days. Thank you.
Senate, anybody? Okay, let's go to the petition. Anybody else who supports?
My Lord, my name is Muzama. I represent the Agricultural and Allied Workers Union, which is an interested party in the matter. Our view is that we associate ourselves with the sentiments raised by counsel for the respondents. And in addition to that, my lords and my ladies, we think that there could be some contractual obligations already entered into between government and certain stakeholders, because we've been seeing we've been seeing activities around launching of housing projects all over the country in certain parts. And so in order for the government to have time to be able to deal with those contractual obligations, the 45 days sought for a stay are necessary so that things could be put into perspective and could be made right. Number two, we also think that listening to your judgment, the housing levy is not entirely unconstitutional. The reasoning behind your decision is that there are certain legislative measures which were not taken to anger the housing levy. We believe that that can be done because first and foremost, you set the fund, then you establish supportive legislation. So we think that is something, that's an option that respondents can look into, going forward. So 45 days are necessary. We humbly pray that you allow that. Thank you.
I'll call petitioners in E181, one person in E181. E181, Okoitio Mtata, and the others. Who is speaking on behalf of those petitioners?
Look, I was holding brief for Senior Counsel Tinde Molo. Our submissions.
Introduce yourself for the record.
My name is Evan Sugada. Our position is as follows. The application for stay is strenuously opposed for these reasons. A declaration of unconstitutionality cannot benefit from a stay order. We were with colleagues, some of my colleagues on the other side, when we dealt with petition number 080 of 2023, Eliud Karanja and others versus the Republic, the CAS case. A similar application was made and was rejected by this court. We asked the court to be guided by the reasoning of the CS case to reject this application for stay on a declaration of unconstitutionality. The same was done in the Levy case. Instructive to note, the case went to the Court of Appeal. This is the CAS case. And the other side argued an application for stay in civil application number 314 of 2023. Similarly,
Number,
a civil application number 314 of 2023. Similarly, the Court of Appeal stated that a declaration of unconstitutionality cannot benefit from a stay. It is for them to get their house in order and come. They are open to go to court and a certificate. The Court of Appeal and a certificate, we will meet them there and we'll be able to respond. We also, on our side, as petitioners, we went to appeal for an order of this court for reimbursement to those who have already paid into the high housing levy under Section 84. This court can make the order for reimbursement so that we save the discomfort that the other side has. Let the money be reimbursed. Thank you.
Who is in 211? 217?
My lords and my lady, my name is Janice. I do appear for the petition. The application for conservatory orders is vehemently opposed for the following reasons. One, what the respondent are seeking before this honorable bench is to extend illegalities. This honorable bench has made a declaration that the impugned Section 84 of the Finance Act is unconstitutional. This honorable court, having deliberated on the issue, made a declarations and therefore it cannot revisit its decision at this juncture. Issue number 2, the respondents had sought 45 days to regularize and to put their house in order. And to some extent, the AG have sought to save the time of judicial time. It's unfortunate that within 45 days, it's not sufficient to regularize the law. And the best way to do is to abandon such objective. The only resort they have is to appeal to the next higher court. We object to the application. That is all.
219.
Lordship, please, Adina, taking it from Mr. Umejo for the petitioners. Your Lordship, we do oppose that application to stay. The law on which the housing levy is founded has already been declared unconstitutional. That law cannot continue to apply. To apply it would mean that the court is reversing the decision that was already made. That can only be done on appeal. So that law cannot continue to apply, and we urge this court to dismiss that application.
221 Law Society.
My Lord and Lady, I join my fellow colleagues in opposing the application that has been made before you for a stay. My Lord, I do not wish to repeat what has been mentioned. What is being sought is a stay, in our view, of a negative order. And my Lord, the courts have spoken several times, more than once, that that is an option that is not available when it comes to stay of its decisions. My Lord, we are finding ourselves in a position we found ourselves as petitioners when we were arguing for interim stay. And my Lord, at that particular time, the respondents were extremely loud that they would be capable of making refunds for any taxes that would be paid. And so, my Lord, at this point, to make an application to seek stay on the ground that they will have difficulty arising from this decision is speaking from both sides of the mouth, and we ask that the court not to entertain that application. Lord, the housing levy is paid by employers and collected through the ITAX system. As of this moment, all employers know that that tax should not be levied. And so therefore, they will not be able to deduct it and submit it to KRA. So there will be no difficulty whatsoever that will be occasioned by that decision. But my Lord, the other issue that is also important is that the ITAX system is just a system for collection of taxes, for ease of collection of taxes. And so it must be configured to be able to collect those taxes. And Lord, we all remember
because we were all here when we were urging the court to stay those decisions, that it took them no less than 1 day or 2 days to configure the system to collect those taxes. So I don't think that that would be a big issue. But Lord, it has been urged already that there are serious, irreversible economic consequences that are going to arise as a result of your decision, specifically on the housing fund. But those consequences have not been placed before. It will only be proper that we have an opportunity to place that through a formal application so that we can also interrogate those grounds and the court can be able to make a reasoned decision on those matters. So as it is, my Lord, the application that has been made before you is highly speculative. It is based on a speculation that there might be contracts that have been signed. And my Lord, that is not a good ground for what I'm saying. My Lord, what would then be the effect if this court was to grant a stay of the decision that it has given? Well, the effect of that is that there will be continued collection of these taxes, despite a very clear and equivocal finding by this court that those taxes are unconstitutional. So we are of the view that there is no probability that any of the respondents would be cited for contempt, because the housing levy is not a fund that is collected automatically by the government, but it's a fund that is collected by the employers and submitted to the Kenya Revenue Authority through ITAX system. Lord, you've also been informed that there is a need for stay so that the Attorney General can be able to seek time to advise his clients on the import of the decision and the other government agencies with regards to the purport of your decision on statutory instruments. But Lord, we also find ourselves in the same position, that after this decision, we have to advise our clients on the effect of this decision. Some of our clients may actually be aggrieved with certain sections of this decision, and my Lord, we do not think that that in itself is a good ground to give or grant stay in the interim. So my Lord, we urge with tremendous humility that application be declined. And my Lord, I would want to also urge, as Mr. Ogada did urge you, because that is something, my Lord, that we did submit on as a law society, that you do make an order for refunds of taxes that have been paid and collected. So then, my Lord, we make it very, very easy for my colleagues to advise their clients and for us to advise our clients. Lord, thank you for that opportunity.
Okay. Azimio la Umoja Party.
My lady and my lords, with your kind permission, my name is Ochieng Oginga. Now, on behalf of Azimio la Umoja One Kenya Coalition, we do oppose the applications for stay. And I submit, firstly, that pursuant to Article 23, 3D, 23, subclause 3D, this court has exercised its powers to grant a declaration of invalidity of the laws. Now, I submit it will be contrary to this particular provision for this court again to issue an order suspending this declaration, because it will negate the object of this particular provision. Secondly, my lady and my lords, to stay the declaration of invalidity will be akin to this court sanctioning a continued violation of the Constitution. And my lords, the applicants have selectively chosen some of the reasons given as to why the housing levy has been suspended and declared invalid. And the court will note it has observed that the levy is not sanctioned in any legal framework. It is being illegally collected by the Kenya Revenue Authority, and it is also discriminatory. Well, so that these, among other reasons, are valid reasons sanctioned by the Constitution upon which an act of parliament can be declared unconstitutional. Now, I urge the court to uphold the holding in McFoy versus United African Bank on any void action is an illegality, and we do not need an order of the court to declare so. Again, my lords will note, factual assertions have been made from the bar and unfounded apprehensions, and I submit the same cannot be a basis to justify the grant of the stay of these court's orders. Now, I refer the court to the decision by the Court of Appeal that is in Jennifer Osodo versus Okumu Osodo and others, that was civil application number 118 of 2020, where the Court of Appeal was emphatic that a negative order is not capable of being stayed. And as such, my lords, I urge the court to dismiss the applications for stay.
E228, Kenya Human Rights Commission and others.
My name is Ochieng Oginga, and we propose the application for stay of the conservatory order of this state. My Lord, we know the law to be that an unconstitutional law is not a law. It confers no rights, imposes no duty, it affords no protection, it's inoperative as if it had not been passed. So as I speak, there's nothing called the affordable housing levy. If you allow it to be the law, will you allow the fund to be collected, or will you also allow KRA to exercise its penal powers to punish those who do not pay
a levy the court has already held unconstitutional. In short, my lord, the public interest and the interest of the public is against the order set by the National Assembly and the state. My lord, I've seen a friend following the judges and people saying that I'm used to the courts declaring, but then continuing. That is the situation our learned colleagues want to go on. That a fact of the court has declared unlawful should still be correct. But my lord, if you could allow, stay the parts that agree with the respondents, then you can also stay the parts that agree with the petitioners. And that is 8% to
16%. Robert Kamwara, 232. Kamwara is not here. Trade Union Congress, Mr. Ogada, you had already spoken. And you
spoken, I'll rest on that.
Okay, thank you. 237, Dr. Frederick Ogola.
My lady and your lords, I oppose strongly the application for stay because a constitutional declaration of a statute or regulation cannot be stayed. If stayed, the court will be entrenching impunity by the way of judicial edict. Secondly, the demand for a refund for the monies that have been deducted so far, we demand that strongly. The declaration of the constitutionality takes effect from the date the legislation was enacted and not from the day the declaration order was made. And Your Honor, if you allow me just to give what you like, I would call it ideological into this. I think the ruling was more ideological way of looking at things because it was more of what you call call to duty. What is wrong is wrong, what is right, and you have said that the house levy is wrong and it does not matter the consequences it has on KRA. Even in case it only has more consequences on Kenyans who are suffering. But of course, I also applaud you highly because you have considered also the consequential approach whereby the consequences on the man and woman of the street for which we as Linda Jamii came for this petition works. And last but not least, I would say that you live here with a virtuous approach because what has become of you as a judge bench to have considered this very painful thing that the government of Kenya was acting. I listened clearly to what Justice Meloi was reading. And I was just
and if you want the correct pronunciation, it's Meoli.
Thank you, my lady. I stand advised. Meoli. So I was very moved when you said something that the law doesn't care about the hardships or, if you like, the economic challenges people have. And being a mother, it made me concerned because the losses of jobs that this is creating, poverty, unable to access healthcare for Kenyans and the rest. I think that we cannot say that the justice or judiciary can tell us that go back to the people elected because you simply told us that it is the judiciary, no, it is the legislature and the executive that are elected that have the suffrage to take care of us. But we are thinking we come to you when we are hurt by these hyenas. And if you tell us to go back to the hyenas, you know very well the consequences.
I think, Daktari, that is language that is not permitted. Here we respect everybody. Everybody has, as I keep saying, whatever you may think of all these people, we are human beings, number one. We have responsibilities under the Constitution, you, I, MPs, lawyers, litigators. So let's respect everybody. So sit down. Thank you very much. Thank you. No, sit down. Sit down. Please sit down. We have heard you. E254 of 2023, Universal Corporation. Yes.
Speak up or come near the mic, please.
254.
Yes.
This is.
I do reiterate my submissions in petition
219.
Sorry, Council, which petition?
219. She was in 219. Yes,
yes, allow me kindly to
Mr.
make a very brief response to the submissions that have been made in response to the application. First and foremost, we begin with the prohibition order. This is not a negative order, but a positive order that commands certain things not to be done. And therefore, this being the case, it is an order that can actually be stayed, because it prohibits the collection of the levy, and therefore that is a positive act that is actually prohibited. Again, the regulations that we've talked about, these are over 1,000 regulations. The impact they have on the operation of the government is huge. It cannot be gainsaid, because regulations are actually the administrative arm of the government. It operates through the regulations, not the statutes themselves. So the effect is actually huge, and therefore it needs an interim protection. In the case of Gatirao Peter Munya versus Dixon when Kibinji, the Court of Appeal was standing that a conservatory order would be issued in such circumstances as to safeguard government operations. And it goes without saying what has been stated by each of the persons who have opposed, that there are operations that are going to be affected, including what is the effective date of the cessation of collection of the levy. Is it from today, or is it from the time the act was enacted? Tomorrow, there will be an avalanche of Kenyans going to KRA to say, give back my money. The following day, you are not given the money because there is a procedure that has to be followed. They will be in court with the contempt applications. So this is a real danger that is facing everyone in the government who must comply with this particular order. There has been submissions as to whether you should make an order to refund. Again, this points to why we need a stay. Yes, there may be a refund at one time in time, but it cannot be tomorrow. It cannot be tomorrow. It has to be within a given period of time after systems are adjusted, advice is given, and appropriate measures are taken, including, and I don't agree with the submission that the law cannot be rectified. That we leave to Parliament. If it has its means and ways of rectifying the law within the 45 days without breaching the Constitution, so well, so good. If it cannot, then it has to find a way of going about. Those remarks, I urge that you grant us the 45 days. You are not in any way negating your order. It is the practice of our courts. The first court of instance would stay its orders to allow parties to go to the second court, third court, and fourth court, if that is necessary. It has happened not only in civil cases, but also in cases such as this one. So you are not negating the order, you are not contradicting yourself, you are not trying to carry on with what are constitutional orders. It is actually the practice of the court to afford the parties to go to the next court, and especially where we are saying, allow us to make a formal application. Thank you.
Maybe before you sit, Mr. Murugara,
yes,
you could just, why 45 days?
It is almost what we need. Number one, we have said if we are to stop this, we have to make the necessary adjustments. Number two, today is the 28th of November. Most entities possibly have deducted either today or the day before to pay salaries. That needs to be looked at because we may have to stop some of the operations that are going on. It's also not speculative that there may be contracts entered into as far as these funds are concerned. If that is the case, you really have to know how to wriggle out of those contracts without again facing an avalanche of cases and arbitrations regarding breaches of contract. So that's why we need the 45 days.
My lords and ladies, I'll start by addressing the issue which you have been asked. Mr. Gaya Uchem for the Kenya Revenue Authority. You have asked why 45 days. The reason why we are going for 45 days is because application for refund, KRA has 30 days to make a decision. So if you're given 45 days, that means that you have sufficient time to not only respond to the application, but also to ensure we have moved the court sufficiently to deal with that. I'll go to the next issue raised by learned counsel Ogada on the issue of being told that a declaration of unconstitutionality cannot be suspended. Nothing can be further from the truth, my lord. Petition number 39 of 2017, LSK versus KRA, 39 of 2017. The court placed the threshold for the same and said, the decision whether to delay the application of a declaration of nullity should therefore turn on not a consideration of the role of the court and the legislature, but rather the consideration listed earlier relating to the effect of the immediate declaration on the public. And that is what we are asking today. KRA has come before you and telling you the effect of that declaration. And the issue of suspension has also been done before. In civil application number 47 of 2023, KRA versus Judith Kiragu, where the stay with regard to the declaration with regard to section 4A and 4B was issued. So we are not telling you, what we are asking for is not an open issue. Suspension of declaration has been done before, and it's recognized by law. Finally, the ODEC on the effective date of unconstitutionality also state that this court has that mandate and has that obligatory jurisdiction to issue order suspending the declaration. And that is what we are here before you, asking you. We're telling you, Mr. Ogada has clearly written that he wants an order of reimbursement. And we're asking you, no, kindly give us that reprieve. Stop us from those applications for the time being. Only 45 days, no more. That is all from KRA.
Okay, thank you very much. We'll consider those arguments. But before we give any further directions, there is a ruling to be delivered. Mr. Isa, Dr. Bargoria. You are lucky you've come when our blood sugars are low, otherwise we would have issued warrants the way we act in Kibera. If you don't appear on time, we go and look for you. Thank you.
Sorry, I was the of the case, and my client was ready for me, so we apologize for that.
Thank you. Yes, Justice Meoli will read the decision of the court.
This is the ruling in respect of the contempt application dated 4th of July 2023, wherein the petitioners sought for the court to determine whether Mr. Daniel Kito Bargoria, the Director General of Energy and Petroleum Regulatory Authority, that's EPRA, is in contempt of the orders of the court issued on the 30th of June 2023, which had temporarily stayed the implementation of the Finance Act 2023. The court had oral submissions from Mr. Isa Mansour, counsel for the alleged contemner, that is Mr. Bargoria, and one of the petitioners, Senator Okia Mtata. It is right that court orders are not made in vain, and a party against whom an order is directed must obey it, the authority being Kyoga Hodias and others, where the court defined a contempt of court as conduct that defies the authority or dignity of a court. The nature of contempt of court was described in Stuart Robertson and Her Majesty's Advocate as follows. It's an English decision. Contempt of court is constituted by conduct that denotes willful defiance of or disrespect towards the court, or that will willfully challenge, or that willfully challenges or affronts the authority of the court or the supremacy of the law, whether in civil or criminal proceedings. We have cited at length the decision of the Supreme Court in Republic versus Ahmad Abolfadi Mohammed and another, where the court explained reasons or gave the rationale for why courts punish contempt. And again, in the second passage that we have cited, and I think I can read it, the Supreme Court explained or set out the standard of proof required to convict an alleged contemner for contempt of court, and the rationale for this standard as follows, and I quote, "We are also conscious of the standard of proof in contempt matters. The standard of proof in cases of contempt of court is well established. In the case of Mutitika versus Baharini Farm Limited, the Court of Appeal held that, in our view, the standard of proof in contempt proceedings must be higher than proof on the balance of probabilities, almost, but not exactly beyond reasonable doubt. The standard of proof beyond reasonable doubt ought to be left where it belongs, that is, in criminal cases, and it is not safe to extend it to an offense which can be said to be quasi-criminal in nature. The rationale for this standard, the Court of Appeal continued to state, the Supreme Court continued to state, is that if cited for contempt and the prayer sought is for committal to jail, the liberty of the contemner will be affected. As such, the standard of proof is higher than the standard in civil cases. This power to commit a person to jail must be exercised with utmost care and exercised only as a last resort. It is of utmost importance, therefore, for the respondents to establish that the alleged contemner's conduct was deliberate in the sense that he or she willfully acted in a manner that flouted the court order. And in this case, the question we are asking is the same one that was asked in that case, whether the respondent or contemner or alleged contemner willfully disobeyed the court's order. The two related ingredients of willful disobedience and knowledge of willful disobedience and knowledge of the order are critical in a successful contempt application. In the past, it was held by superior courts that for an applicant to succeed in contempt proceedings, he must prove personal service of the subject orders and the attendant penal notice upon the alleged contemner. That was in Nyamongo, the case of Nyamongo and Kenya Post. In recent years, however, superior courts have stated that where the applicant is able to demonstrate awareness by such contemner of the orders and not necessarily personal service of the order upon the contemner, such awareness is sufficient. Notably, the courts emphasize the high degree of proof required as exemplified by in the exhortations of the Court of Appeal in the Mutitika, which I've already read. Turning to the factual issues in this case, it is not in dispute that on 30th of June 2023, this court issued an interim stage upon presentation of petition, an order at interim stage upon presentation of petition 181 of 2023 as follows. This matter coming up on 30th June 2023 for directions on the notice of motion dated 29th June 2023 before Honorable Justice M. Thande. Upon considering the same, it is hereby ordered, 1, that the application be served today, 30th June 2023, upon all parties. 2, that responses be filed and served by 4th July 2023. 3, that I am satisfied that the application meets the test for conservatory orders, and I do grant prayers 2 and 3 of the application until 5th July, when the matter is scheduled for mention for directions. Before we proceed, it will be apposite to put the foresaid in context, in the context of the matter before the court. At the time of the filing, the respondents captured in petition number 181 of 2023 were the Cabinet Secretary for the National Treasury and Planning, the Attorney General of the National Assembly, and the Speaker of the National Assembly. The Commissioner General, Kenya Revenue Authority, the Senate, Consumer Federation of Kenya, COFEC, and Kenya Export Floriculture, Horticulture, and Allied Workers Union were, yes, the respondents, this was part of the respondents. And the final party as a respondent was the Kenya Export Floriculture, Horticulture, and Allied Workers Union. These latter two, were interested parties. The specifics of the conservatory order issued by the court were that pending the hearing and determination of the application, that must be the extracted order, and/or the petition, the Honorable Court is hereby issues a conservatory order suspending the Finance Act. Pending the hearing and determination of the application and of petition, the Honorable Court hereby issues an interim order of prohibiting the respondent and interested parties or their agents howsoever acting from giving effect to the Finance Act. The thrust of the petitioner's case against the alleged contender is that he published a press release setting out the increase in the price of petroleum products following the coming into force of the Finance Act. That the effect of the press release was to notify the public on the changes to fuel prices effective 1st July 2023 in compliance with the revised VAT rates from 8% to 16% on petroleum products. The finance bill having been assented to by the President on 26th June. Mr. Issa pointed out that neither the alleged contender nor EPRA, that is the one with the long name, were a party to the proceedings at the time the court issued the orders on 30th June and were yet to be enjoined to these proceedings. And that on 30th June, the alleged contender was simply discharging his duties as the Director General of EPRA by issuing a press release in a timely fashion, as has always been the norm. Thus, the alleged contender stated that he was being prosecuted for his effectiveness. Senator Mtata arguing that after the court issued the order, he had proceeded to serve it on the alleged contender on the same day via his WhatsApp number and email address along the petition. That despite being served, the alleged contender declined or neglected to recall the press release. As explained earlier, the two ingredients necessary for a finding of contempt are knowledge of the court order, which the alleged contender denied, and willful disobedience. On the former, the alleged contender argues that neither he nor EPRA were a party to these proceedings. Evidently, the said argument is true, but nevertheless, reviewing the document exhibited as in Matters 0005, it is clear that there was a WhatsApp conversation between Senator Mtata and the alleged contender, of which the latter does not dispute. What is contended by the alleged contender is that at the time the court issued the order, he had already issued the press release in discharge of his duties as Director General of EPRA. A cursory look at the WhatsApp extract indicates that the order accompanying documents was sent to the alleged contender at 11:38 p.m., presumably on 30th June 2023. A further perusal of the alleged contender's response, particularly the annexure DKB2, shows that the order of 30th June was issued at 14:25 hours. This court takes judicial notice that the alleged contender issued the press release through EPRA's official, formerly Twitter X account handle at 18:11 hours. What emerges from the foregoing is that despite the court's order having been issued in the afternoon of 30th June 2023, it was not until close to midnight on the 1st of July 2023 that the alleged contender was served with the order. Consequently, by the time he issued the press release, there was no way that the alleged contender could have known about the order. From the facts and the evidence, we find and hold that the Finance Act, having been assented to by the President, took effect on 1st July 2023. The alleged contender, in the performance of his duties as the Director General of EPRA, issued a press release to inform the public of the changes in fuel prices. We hold that the contender did not have knowledge of the order by the time he issued the press release. Further, the petitioners have not put forth any evidence that shows willful disobedience of the order. As was held in Ahmad Abolfadi's case, the standard of proof in contempt applications is high, and the petitioners have failed to surmount this burden. For the reasons we have set out, we find that Mr. Daniel Bargoria is not guilty of contempt. We dismiss the notice of motion dated 4th July 2023, and Mr. Bargoria is discharged from these proceedings. That is the judgment.
Thank you. Okay, we need to deliberate on the application for stay, and we will resume at 3 o'clock.
Bila shaka mtazamaji, ndio picha za moja kwa moja kutoka katika mahakama kuu ambapo majaji watatu akiwemo Christine Mioli kwa sasa wanatoa uamuzi kuhusiana na sheria ya fedha mwaka 2023 na ambapo mpaka sasa hivi suala la matozo ya nyumba au ushuru wa nyumba umetupiliwa mbali katika uamuzi ambao umetolewa na majaji hao watatu, wakisema kwamba ni kinyume na katiba na hivyo basi imewatenga baadhi ya watu wengine. Ni taarifa ambayo tunazidi kufuatilia katika chumba cha matangazo hapa jijini Nairobi, ambapo kwa sasa tunapeperusha matangazo haya moja kwa moja. Na hapo awali mahakama itakuwa inarejea mwendo wa saa 9 ili kuweza kujadili masuala kadha wa kadha, hasa kuhusiana na sheria hiyo ya fedha ya mwaka 2023, swala ambalo lilikuwa limezua tumbo joto hasa miongoni mwa Wakenya, na tunafahamu kwamba mwendo wa baadaye Wakenya watakuwa wanazungumzia hili swala. Kwa hiyo tutazidi kufuatilia kwa kina zaidi tujue ni kipi ambacho kitakuwa kinajitokeza na Wakenya wanasema namna gani kuhusiana na sheria hii ya fedha, hasa matozo ya nyumba, sheria ya ushuru wa nyumba. Hapa studioni nilikuwa na wageni na ambapo nilikuwa nimewaalika hapo awali ili kujadili masuala kadha wa kadha, mbona shilingi ya Kenya imeanguka kufikia sasa, lakini kutokana na muda nitawapa nafasi wazungumzie hatua hii ama uamuzi wa mahakama kuhusiana na swala la matozo ya nyumba ama ushuru wa nyumba kwa mapana na marefu tu, kisha baadaye nitakujuza taarifa za habari. Lakini kwa sasa wacha tuchukue mapumziko mafupi, tunarejea na mengi zaidi, kwa hivyo usiende mbali. Na mtazamaji, ni saa 7:10 saa za Afrika Mashariki. Asante sana kwa kujiunga nasi kwenye taarifa za saa 7, lakini kwanza kabisa wacha nikujuze vidokezo. Mahakama Kuu yatupilia mbali ushuru wa nyumba. Majaji wanasema hatua hiyo ni kinyume na katiba. Kinara wa ODM Raila Odinga azuru kaunti ya Kisii huku akitarajiwa kuzindua zoezi la kuwasajili wanachama. Na mbunge Salasi atakiwa kulipa deni la shilingi 500,000 mara moja.
Judgment is hereby entered in favor of the claimant as against the respondent for the sum of 500,000 plus cost of the suit and interest at court rate from the date of judgment till payment in full.
Na mtazamaji, kwa hayo na mengine mengi tuandamane hadi tamati, lakini kwanza kabisa Mahakama Kuu ikiongozwa na majaji watatu wametupilia mbali swala la sheria ya fedha hasa kuhusiana na matozo ya nyumba, swala ambalo lilikuwa limeleta utata. Hebu tusikilize majaji walisema nini.
Of the Senate in his letter dated 15th of June 2023 is not idle, as the Supreme Court in the matter of the Speaker of the Senate and another were discussing the role of the speakers of the respective house of the parliament, observed as follows. I think it's necessary that I read part of this. This is what the Supreme Court said. Is it in doubt, that is quote, is it in doubt, in view of the formal provisions of the law, when and how the question for the consideration of the two speakers arises under Article 110 of the Constitution? We do not think so. No, Mr. Norje submitted the requirement for a joint resolution of the question whether a money bill is one concerning counties is a mandatory one, and the legislative path is well laid out. It starts with the determination of the question by either speaker, depending on the origin of the bill. Such a determination is communicated to the other speaker with a view to obtaining concurrence. Failing a concurrence, the two speakers are to jointly resolve the question. Both sets of standing orders are crystal clear on this scenario, and both on this point, as we find, faithfully reflect the terms of the Constitution itself. It is clear, though some of the council appearing before us appear to overlook this, that the business of considering passing of any bill is not to be embarked upon and concluded.
The notice issued by KRA informing the public that it has appointed a cabinet. It has been appointed by the Cabinet Secretary. Ministry of Lands, Public Works, Housing and Urban Development to collect the housing levy does not have any legal basis under the KRA Act. We have also looked at the Public Finance Management Act, which permits the Cabinet Secretary, in this case the Cabinet Secretary responsible for finance, to designate in writing persons as receivers of government revenue. It is therefore not possible for the Cabinet Minister, Cabinet Secretary for Ministry of Lands, Public Works, Housing and Urban Development to authorize collection of a levy which, as we have held, constitutes a tax under Article 209 of the Constitution. We therefore reject the argument by KRA that it is entitled to collect housing levy merely on the ground that it is entitled to charge a commission on the amount it collects in accordance with Section 1610BA of the KRA Act. The authority to collect taxes must be issued by the Cabinet Secretary for Finance. As we have shown.
Kikao cha Mahakama Kuu itakuwa inarejea mwendo wa saa 9 kamili na tutakujuza mengi mwendo wa jioni, lakini kwa sasa kama nilivyokuwa nimekuarifu kwamba kinara wa ODM Raila Amolo Odinga kwa sasa yupo katika kaunti Kisii na ambapo anahutubia wakazi eneo hilo katika uga wa Jamache Green. Odinga vilevile anatarajiwa kuzindua rasmi zoezi la usajili wa wanachama wa ODM eneo hilo. Hebu tuvuke moja kwa moja tusikilize ni kipi ambacho kinaendelea katika kaunti ya Kisii. Ndio viongozi ambao wameambatana na kinara wa ODM Raila Odinga katika kaunti ya Kisii. Kumbuka kwa sasa wanaendeleza mchakato wa usajili wa wanachama ili kuboresha chama hicho na kukipa nguvu zaidi. Ni taarifa ambayo tutakuwa tunazidi kufuatilia kwa kina zaidi. Tukujuze mengi mwendo wa baadaye, lakini usisahau kwamba kwa sasa tuna mengi ambayo tumekuandalia katika chumba cha habari. Lakini kwa sasa naarifiwa tusikilize kile ambacho viongozi wanazungumza katika kaunti ya Kisii.
wanachama wetu tukaacha Janet Ongera ambaye alikuwa mwanachama wetu wa ODM. Tukakupatia kiti kirasasi. Lakini kama huyo mama ameanza kumisbehave, si tutachukua hiyo kiti? Tutachukua ama tupatie mtu mwingine, lakini huyo mama amekuwa na tabia mbaya. Niseme. Sisi kama wana ODM tumesema Raila hawezi kuwa na roho nyepesi. Mwanaume atakuja sasa 2026 aanze
Kumbuka chama cha ODM kinatarajiwa kufanya uchaguzi wake katika maeneo mbalimbali mapema mwaka ujao. Mwezi Machi, ambapo chama hicho kitakuwa kinachagua baadhi ya viongozi katika sehemu mbalimbali katika kaunti zote 47, ndiposa mchakato wa usajili wa wanachama tayari umeshaanza. Kumbuka wiki iliyopita kinara wa ODM Raila Odinga alikuwa katika kaunti ya Migori ili kuendesha shughuli hiyo. Kwa sasa tunaangazia taarifa nyingine, ambapo tume inaangazia masuala ya filamu nchini. KFC pamoja na shirika la kitaifa kuhusu takwimu zimeshirikiana kuzindua akaunti ya tasnia ya filamu nchini inayofahamika kama FISA. FISA inatarajiwa kujihusisha na mjadala wa mchango wa kiuchumi katika tasnia ya filamu ili kuwezesha pato la taifa. Akaunti hiyo itazingatia pato la filamu, ajira inayotoka katika tasnia hii, pamoja na marupurupu ya wale ambao wameajiriwa katika sekta ya filamu.
It encompasses a wide range of sectors, including arts and culture, design, technology, and entertainment. As we navigate this dynamic landscape, it is imperative that we recognize the intrinsic link between the creative economy and the aspirations of our youth. But why FISA? Kenya's film industry has continued to witness rapid growth owing to liberalization of the media environment, while its significance in the economy is believed to be high. Clarity with respect to what constitutes the industry in terms of value addition, trade, investment, and employment is lacking. Unlike other economic activities, film is not clearly defined as an industry, but rather an amalgamation of various industries. As a result, the industry's direct contribution to the Kenya's gross domestic product, GDP, is not measured. Yet the Kenya film industry has great potential to stimulate economic growth through infrastructural development, tourism investment, employment creation, and other areas. The industry broadly comprises two intimately linked components: the production industry, which produces content for both film and television viewing, and the distribution side, which comprises business that sell and supply produce film content to cinemas, television broadcasters, rental, retail, and online outlets. I am sure most of you are conversant with other components of the film industry which
Tukiachana na taarifa hiyo, kwa sasa tunaelekea maeneo mengine ambapo mahakama ya Kakamega imemwagiza mbunge wa Mumias Mashariki Peter Salasia kumlipa mfanyabiashara Robert Luta deni lake la takriban shilingi 500,000 pamoja na riba na gharama ya mahakama. Mfanyabiashara huyo pia aliwasilisha ushahidi wa stakabadhi za benki ya KCB tawi la Mumias kudhihirisha mbele ya mahakama kwamba alituma pesa hizo kwa akaunti ya benki ya Salasia. Kwa upande wake, Salasia alikuwa amekanusha kwamba alikopeshwa pesa hizo na mlalamishi, huku akidai kuwa yeye ndiye alimkopesha Luta shilingi milioni 1 kupitia kwa mshauri wake wa kisiasa Bernard Luta. Katika uamuzi wa hakimu, Gladys Kiama alipuuzilia mbali madai ya mbunge huyo, akihoji kuwa hayakuwa na ushahidi wowote.
Luta, he sued the member of parliament for Mumias East, and today the court has made a ruling in favor of my client. that the MP should pay the money that he owes my client. And we are now proceeding to move to execute the judgment.
In the end, I find that the claimant has successfully proven his claim as against the respondent. I further find that the respondent has not successfully proven his claim as against the claimant. His counterclaim cannot stand. I hereby order as follows. Judgment is hereby entered in favor of the claimant as against the respondent for the sum of 500,000 plus costs of the suit and interest at court rate from the date of judgment till payment in full.
Tukitoka maeneo hayo tunaelekea katika kaunti ya Kakamega ambapo wakazi wa kaunti ya Kakamega wametishia kuandamana kutokana na visa vya wizi wa pikipiki na mauaji ambavyo vimeonekana kukithiri eneo hilo. Hatua hii inawadia wakati ambapo pikipiki 5 zimeripotiwa kuibiwa na wahuni kwa kipindi cha mwezi mmoja uliopita, huku baadhi ya wahudumu wa bodaboda wakiuliwa wakiongozwa na viongozi wa nyumba 10 Alfred Amambia na Isaac Otiende. Wakazi hao sasa wanawataka maafisa wa polisi eneo hilo kuimarisha msako ili kuwakabili wahuni hao. Kadhalika wamerai serikali ya kaunti kuweka taa katika maeneo hayo zinazotumia miale ya jua katika maeneo ya giza ambapo visa hivyo hufanyika ili kupunguza uhalifu eneo hilo.
Njia kutoka Musonga pia mtu akadungwa visu mingi sana kwa kichwa. Alafu pia hapa kuna wanafunzi pia asubuhi mapema wakati wanaraukia shule wananyang'anywa uniform asubuhi. Na usiku pia tumekuwa na visa vya watu kuvunja nyumba na kuchukua vitu kama sana TV za flat screen. Hapa ni Kakamega town. Waangalie wajaribu kuweka lights. Ukiweka lights visa za uhalifu zinapunguka. Mimi kitu ningependa kuonya watu wetu wa bodaboda ya kwamba ikifika saa 12:30 ya jioni usikubali kubeba mtu ambaye haumjui.
We want is development and security. Security is most important to our lives. So kama governor na MCA hawata address the issue of security, we have the
Taarifa hiyo kutoka maeneo haya magharibi ya Kenya kwa sasa inatupeleka katika pumziko mafupi, lakini tukirejea tunakuja na mengi zaidi, kwa hivyo usiende mbali. Naam, karibu tena mtazamaji. Kama nilivyokuwa nimekuarifu kwamba tutakuwa na mazungumzo chanya hasa kuhusiana na kushuka kwa shilingi ya Kenya, na pia vile nitakuwa nawapa nafasi wageni kuzungumzia hili swala la sheria fedha, ambapo mahakama imetoa uamuzi, na tubaini tu kwa undani zaidi ni hatua ipi labda huenda ikafata baada ya mahakama kuu kutoa uamuzi huo. Na kama nilivyokuwa nimekuarifu kwamba studioni na wageni ambaye ameketi upande wa kulia, upande wangu anafahamika kama Noel Ikirara ambaye ni mtaalam wa masuala ya uchumi, na ambaye ameketi upande wa kushoto anafahamika kama Sam Kimani Mwangi ambaye ni mtaalamu wa sera ya masuala ya umma. Na pia vile tutakuwa tunajadili kwa undani zaidi kuhusiana na hatua hii na iwapo Wakenya watapata afueni kutokana na sheria ya fedha, ambapo mahakama imetupilia mbali swala la matozo ya nyumba au ushuru wa nyumba, ambapo serikali ilikuwa inalenga kujenga nyumba kadhaa humu nchini Kenya ili kuweza kuwafaa wananchi. Nikianza nawe Noel, kuhusiana na sheria ya fedha na uamuzi ambao umetolewa na majaji hao, ni kipi ambacho labda huenda likafuata baada ya hapo?
Asante Bwana Paul. Ni vizuri kwamba tumesikiza koti vile wameamua majaji, na kuna mambo kadhaa wanaweza fanya. Serikali inaweza enda kwa koti ya juu ya appeal kuleta kesi kama wanaweza rudisha hiyo sheria, lakini pia Wakenya pia wamepata nafasi pia kuongea zaidi kuhusu hiyo sheria, na vile wamesema kuna watu, hasa watu wanalipa mshahara ndio ni kama waliumia kiasi. Kwa hivyo ni
lugha ya Kiingereza wanasema middle class.
Middle class ndio. Hao ndio waliumia zaidi. Kwa hivyo serikali itabidi sasa warudi kuangalia tena na labda kufanya hiyo public participation vile wanasema. Ndio.
Mwangi, kuhusiana na hilo swala la public participation,
yes.
Pia vile nimeona mahakama imesema kwamba iliridhishwa na jinsi ambavyo bunge la kitaifa lilikuwa limewahusisha wale professionals, technocrats kutoka mashirika tofauti. Labda baada ya hapo Wakenya, kuna uwezekano wa Wakenya kurudishiwa pesa zao?
Itategemea vile majaji wameamua. Waweza kusitisha matozo ya ushuru wa nyumba kuchukuliwa na serikali. Pia waweza sema na ambao waliokuwa wametozwa matozo yale warudishiwe. So itategemea uamuzi wa majaji hasa umekuwa upi na umefika kiwango kipi. La mno kusema ni kwamba kuna uwezekano ambao waliokuwa kama defendants, ambao sijui tuwaite washtakiwa, kwenda katika koti ya rufaa na kudai pengine yasikizwe upya na waone kama kutakuwa na jambo ambalo pengine huenda likaendeleza kuokotwa kwa matozo ya ushuru wa nyumba. Lakini kulingana na koti ni kwamba si kikatiba matozo yale kuokotwa, na yafaa kusitizwa mara moja.
Naam, asante sana kwa mchango huo. Kuhusiana na hili swala la dhamani ya shilingi ya Kenya ikilinganishwa na dola, hili ni swala ambalo limeleta tumbo joto hasa miongoni mwa Wakenya, wawekezaji, investors na vitu kama hivyo. Kuchanganua tu kwa undani zaidi, kuna ripoti ambayo nilikuwa nimesoma ambapo wabunge sasa wanamshinikiza waziri wa fedha Njuguna Ndung'u pamoja na gavana wa CBK ili kuweza kuhakikisha kwamba shilingi ya Kenya inapata nguvu. Kwa faida ya mtazamaji, nini hasa labda imechangia kuporomoka kwa shilingi ya Kenya?
Okay, asante. Shilingi ya Kenya imeshuka juu ya mambo kadhaa. Ya kwanza kuna hiyo mfumuko wa bei. Gharama ya maisha imepanda juu, na sana hiyo inafanya pesa hiyo ya taifa kukosa dhamana, na pia tunajua riba za mikopo za benki pia zimepanda pia. Na pia hiyo inaleta sana inaleta dhamana ya shilingi kupanda, lakini pia hii mambo ya mfumuko wa bei pia inashusha kidogo. Pia tunajua inflation ndio. Na pia tunajua katika dunia dola Marekani imezidi kupata nguvu wakati huu, na pia tunajua mambo kama mafuta yenye ni ukiangalia uagizaji ya Kenya, mafuta ndio iko juu sana. Tunanunua mafuta na tunanunua kutumia dola. Sasa hiyo kununua mafuta inaleta kwa kutumia dola inafanya sasa shilingi ya Kenya kushuka, kuteremka pia. Na ukiangalia pia tukiongea kidogo kuhusu mfumuko wa bei, tumeona kwamba pia stima pia imepanda kwa asilimia karibu 45 kutoka mwaka uliopita. Kwa hivyo tunaona hii mambo sana sana, hiyo mfumuko wa bei ndio imeleta dhamana ya shilingi chini, na pia hiyo uagizaji yetu kwamba Kenya iko na tunaita kwa Kiingereza trade deficit. Kwamba mauzo yetu ya nje exports iko chini kuliko uagizaji zetu imports. Hiyo inamaanisha kwamba tunahitaji dola kununua vitu kutoka mataifa nje. Na kama bidhaa yoyote ukitaka dola nyingi, inamaanisha kwa hiyo bei ya dola inapanda. Ndio. Lakini hiyo ndio.
Na je, mapendekezo ya wabunge kuipa pressure CBK,
ndio
unahisi CBK ina uwezo wa kuimarisha shilingi ya Kenya?
Ndio, unafaa kuna uwezo kwa sababu ukiangalia kwa vile nimesema, kuna hiyo mambo mawili, kwamba kuna hiyo riba na pia mfumuko wa bei. Unafaa kufanya hiyo kupima vizuri, ndio dhamana ya shilingi ikuwe sawa. Kwa hivyo ni kitu wanaweza kufanya, lakini pia kuna mambo ya nje kama vita huko Russia tuseme pia, na pia kuna mambo ya ndani yenye inaleta hiyo shida, lakini wanafaa kuwa na hiyo uwezo ya
kurejesha shilingi,
lakini pia wanafaa pia kuambia wananchi, kueleza vizuri ni kwa nini shilingi imeshuka na itachukua muda gani kabla mambo yaanze kuangalia kuwa vizuri.
Naam, asante sana kwa mchango huo Noel. Mwangi, umemsikiliza vizuri Noel akizungumzia hilo swala. Na wabunge kwa sasa wanamtia pressure sana waziri wa fedha Njuguna Ndung'u, Treasury CS, na pia vile gavana wa Benki Kuu ya Kenya. Je, jitihada zao za kuimarisha shilingi ya Kenya huenda ikafua dafu?
Huenda. Ni vizuri nikitaka tu kuongezea kidogo yale mwenzangu amesema. Ni kwamba wajua, shida kubwa ni kwamba sio shilingi ya Kenya ambayo imeathirika na dhamani yake ukilinganisha dhidi ya dola ya Umarekani. Sarafu nyingi za mataifa mengine pia yameathirika, kwa sababu mwaka uliopita Marekani ilipoona mfumuko wa bei umekuwa juu sana, umefika hadi 9%, kuna kitu kimoja walifanya. Kwanza waliongeza riba yao kutoka 0 hadi 5, na kwa sababu hiyo shilingi yao au dola yao ikawa na dhamana kuu dhidi ya sarafu zingine zote za dunia. Lakini hata vile ni vizuri ujue, kama mwenzangu amesema, shida kubwa yetu ni kwamba uigizaji wetu na mauzo ya nje, unapolinganisha wapata ya kwamba uigizaji wetu ni mwingi sana, mauzo yetu ya nje ni ndogo. Kumaanisha kwamba kwa sababu uigizaji wetu wote wahitaji dola katika kufanya biashara ile, wapata kwamba reserve zetu za dola katika nchi zimepungua. Ukiangalia deni la nchi pia wakuta ya kwamba tuna deni ambalo afikia trilioni 10.5, 50 au 51%, ambayo ni deni za nje ambazo zalipwa kwa dola pia. Mambo yale yote yakiletwa pamoja, ndio unaona tumekuwa na upungufu wa dola katika nchi, bei ya dola inakuwa juu, dhamani yetu ya shilingi yapungua. Kuna mengi ambayo yaweza kufanywa, lakini ukweli ni kwamba yatatumia muda. Noel yeye akiwa kama ambaye ana ujuzi wa mambo ya uchumi atakuelezea mambo mengi hayatafanyika kwa siku moja. Hata tukimshinikiza waziri wa fedha, Central Bank Governor, tuambie lazima within mwezi mmoja shilingi irudi, watajaribu, lakini mambo mengi ambayo yahitajika kufanywa, shilingi ianze kupata dhamana ambayo inapanda dhidi ya dola, ni kwamba itagharimu muda, kwa sababu inamaanisha tuweke sera ambazo zitatuwezesha kama nchi kuongeza reserve ya dola katika nchi. Jambo la kwanza ni tuongeze mapato ambayo yatokana kutoka na nje kuja kwetu, FDIs, ambayo pia tuwafanya vibaya sana Tanzania na wengine wanawavutia waigizaji kutoka nje zaidi ya vile tunafanya kwa sababu ya tax regime yetu kama nchi. Kwa hivyo mengi ya kufanywa, itabidi tuwe wavumilivu, tungoje serikali na tuipe what we call in English benefit of the doubt. Na tutarajia kwamba wakishinikishwa hawa wawili, kwa sababu pia wanao uwezo, watasaidia na shilingi yetu yaanze kupata dhamana ikipanda.
Na Noel, ulikuwa umesema kwamba serikali ipatiwe muda. Labda taifa la Kenya inaweza ikachukua muda upi ndiposa kuimarisha shilingi ya Kenya? Na labda kutokana na kushuka kwa shilingi ya Kenya, Wakenya wanaathirika namna gani hasa kipindi hiki? Na mbali na hayo pia hili swala la gharama ya maisha imeendelea kupanda.
Kwa swala la kwanza kuhusu serikali, ile muda tunawapatia, tukumbuke pia serikali kuna vile Sama amesema madeni na sana sana kuna madeni ya nje yenye tunalipa na dola. Ile Eurobond yenye tunafaa kulipa mwaka ujao, sio bilioni 2 ya dola. Hiyo ni pesa nyingi sana. Na ndio maana serikali wanataka madola na mabenki pia. Ukienda kwa benki sasa ni ngumu kununua dola, hata kupata ile kiasi unataka, na pia bei iko juu. So kwa hivyo ile madeni ya Eurobond, serikali wanafaa kulipa hiyo deni juu. Tusipolipa hiyo deni, Kenya itakuwa na shida zaidi kuliko tunazo sasa hivi.
Lakini itakuwa vigumu kulipa yote kwa wakati mmoja.
Ni kweli.
Walipe nusu.
Rais Ruto alisema juzi kwamba mwezi ujao, mwezi wa Disemba, kwamba wanafaa kulipa milioni 300 ya dola katika hiyo Eurobond. Kwa hivyo bado kuna hiyo imebaki kubwa. Kwa hivyo na ndio maana ushuru tumesikia hiyo imepanda, kwa sababu serikali inataka kulipa hiyo deni. Kwa hivyo ni jambo ngumu sana. Siwezi sema itachukua muda gani kwa shilingi yetu kwa sawa, lakini ukiangalia duniani wamesema kwamba uchumi wa dunia itaimarika baada ya mwaka ujao. Imaanisha mwaka tuseme miaka 2 kutoka sasa. Hiyo ni duniani, na nchi ya Marekani ni ya kwanza uchumi yao kuimarika kabla sasa sisi wote tunaanza kwa hivyo Wakenya itabidi vile wamesema wajikaze
muda zaidi.
Lakini Wakenya, uzuri wetu tuna nafasi kuongea na kuuliza maswali kwa wajumbe wetu na rais wetu ni nini wanaweza fanya, kwa sababu Kenya ina mali ama nasema the resources mengi tunaweza tumia kujiinua. Kwa hivyo wananchi wanafaa kufanya bajeti zao vizuri na kutumia pesa vizuri vile vifaa. Na pia vile wanasema, umesikia pia kuna juzi niliona kuna kampuni mingi watakuwa na inaitwa nini, profits zitakuwa zimeshuka mwaka huu. Inamaanisha kwamba hata kuna wafanyikazi wanaweza wachishwa kazi mwaka ujao.
Naam.
Kwa hivyo mwananchi anafaa kuuliza maswali kwa wajumbe na rais, lakini pia kuona unaweza fanya nini na
kuimarisha shilingi ya Kenya
na pia maisha yako kama mwananchi, kutafuta kufanya ukulima na mambo mengine kujiinua, kwa sababu itakuwa ngumu.
Kulikuwa na pendekezo ambalo Rais William Ruto alikuwa ametoa kwamba Kenya inunue mafuta kwa shilingi ya Kenya.
Ndio.
Sijui kama pendekezo hilo kidogo itakuwa ni afueni kwa Wakenya?
Ndio, ingekuwa na ufueni, lakini unakumbuka alisema hiyo itaanza mwezi wa 4-5 mwaka huu, lakini imechelewa. Kwa hivyo wanafaa kujibu hiyo swali, lakini pia najua duniani kuna mataifa wanataka kutotumia dola sana, kutumia pesa zao ndio tusiwe na hii shida ya dola. Kwa hivyo ni jambo iko na uzuri wake, lakini kuitekeleza ndio ngumu labda. Na wanafaa kutueleza itafanywa vipi na itachukua muda gani, juu imechelewa kidogo.
Mwangi, umesikiliza vizuri Noel akijaribu kuelezea mataifa mengine yanapendekeza kutumia fedha zao ama sarafu yao. Je, hii itakuwa na uwezekano ama itakuwa ni vuta ni kuvute, na huenda labda ikaweka taifa la Kenya katika hali ngumu? Manake kwa sasa tunatoa mafuta Russia.
Ukweli ni kwamba kuna kitu na Kiingereza tukiita petrodollar system, ambayo ni mkataba katika wanaofanya biashara ya mafuta duniani, ya kwamba mafuta yote ya petroli na bidhaa zingine za petroli itauzwa kwa kutumia sarafu ya Marekani ambayo ni dola. Na jambo lile limekuwa na kulete utata mwingi mara ambapo dhamana ya dola inapanda, kwa sababu ni kumaanisha inabidi bei ya bidhaa hiyo pia ipande katika soko la dunia. Mataifa kunayo ambayo yamekuja pamoja yanajiita BRIC, ambayo la mno la kusema ni kwamba moja ya mataifa yale ni China, kuna ile ingine ya India, kuna Russia na mengineo. China na India ndio ambao ni watumizi wakubwa wa bidhaa za petroli duniani. Russia kwa upande mwingine na Saudi Arabia, wale nao pia ndio ambao ni producers ambao ndio wakubwa wa bidhaa ile. Kama kwamba watakutana na waweze kufaulu katika mbinu yao au sera zao za kusema watauza mafuta kwa sarafu zao wenyewe, ukweli ni kwamba dhamana ya dola katika duniani itapungua. Lile ambalo hatuna uhakika nalo ni kwamba itaugalimu muda upi mambo yale kufanyika, lakini ukweli ni kwamba kama miaka ijavyo ni kwamba mambo yatabadilika. Soko la dunia, sarafu ambazo zitakuwa zikitumika ziwe nyingi. Nchi kama Kenya ifike mahali ya kwamba si ugumu kununua mafuta, na ni vizuri kusema ya kwamba katika uigizaji wa Kenya mafuta ya petroli na bidhaa zingine huchukua 35%. Ukiangalia uigizaji ule ambao ni dola bilioni kama 24,000, karibu nusu yake ni mafuta peke yake, ambao utakuta pengine tuna uigizaji wa mafuta wa bilioni kama shilingi 600-700. Halafu yote unakuta pia twasema yote yaigizwa, uigizaji ule ufanyike katika dola. Kwa hivyo mambo yanavyobadilika na kuwezesha nchi kufanya uigizaji kutumia shilingi yake, itaifanya kuwa si lazima iwe na reserves za dola, na hiyo itasaidia katika kuregulate au kufanya mabadiliko kwa thamana ya shilingi ya Kenya ili iweze kupanda. Yes.
Asante sana kwa mchango huo. Noel, kuna hili pendekezo ambalo serikali kwa sasa inafanya ya kukusanya ushuru zaidi. Nafahamu kwamba itaathiri serikali katika ulipaji wa madeni. Na sijui labda itachukua kiwango cha muda upi ukilinganisha na uzalishaji, productivity.
Okay. So kwa hivyo ushuru, kazi ya serikali tunajua, tuseme kuna mambo matatu. kwa jumla, ikiwa na vita kutoka nchi nyingine kuwa salama, na pia kuwa na ugonjwa kama ile ya COVID kusaidia wananchi. Alafu watatu pia kulipa deni ya juu. Hiyo deni tuseme ni ya serikali, lakini ni ya nchi yetu, na sisi kama wananchi hiyo deni ni yetu. Kwa hivyo serikali wanafaa kutulipisha ushuru ndio kwa na hiyo uweze kufanya hiyo kazi, hiyo mambo matatu. Kwa hivyo ile deni vile tuliambiwa kuna trilioni 10 Sama alisema ya deni, karibu nusu yake ni deni ya nje. Deni ya ndani, deni ya nchi inalipwa na shilingi yetu. Kwa hivyo hiyo haina shida kubwa, kwa sababu benki kuu inaweza lipa hiyo, ama inaweza ongeza hiyo pesa ya shilingi. Lakini hiyo deni ya nje iko kwa dola, lazima kwanza ukumbuke pia kwa mauzo ya nje Kenya, chai inakuanga inatuletea madola nyingi, na pia uzaji wa maua, mboga na pia matunda. Lakini kwa sasa tunajua haijapanda zaidi hiyo mauzo nje. Kwa hivyo ushuru, kumbuka kuna hiyo tunasema hiyo upungufu wa kifedha, yani hiyo nakisi ya biashara, hiyo trade deficit iko kubwa zaidi. Na kama tuwezi pandisha mauzo ya nje kupunguza, tunaweza pia kupunguza pia uagizaji. Lakini kwa uagizaji kama mafuta, kwa sasa Kenya hatuna mafuta yetu. Ile ya Turkana sijui ilifikia wapi. Yeah. So na vizuri ulisema hapo kwa habari, ulisema kuna nia ya kutumia miale ya jua, sola ama upepo. Hiyo ni jambo kama sisi wa Kenya na makampuni na viwanda tunaweza anza kutumia sola ama hiyo wind power kupunguza ile pesa tunalipa kwa mafuta na pia kwa umeme, stima. Kwa hivyo tuna uwezo hapo, lakini serikali lazima wakusanye ushuru na kulipa hiyo deni ya Eurobond, kwa sababu wasipoweza kurestructure hiyo madeni, hatutaki kuwa kama nchi zingine kama Zambia ama Ghana yenye walikuwa au kuweza kulipa mikopo yao. Kwa hivyo sioni jambo lingine serikali inaweza fanya, lakini labda kueleza wananchi ni kwa nini tunafanya hivi, itachukua muda gani. Juu wako na watu wana ujuzi sana kutueleza itachukua muda gani, wanafanya nini, na sisi kama Wakenya tunaweza fanya nini ndio tusiwe na maisha, tuvumilie kiasi. Kwa hivyo vile tunasema hiyo kueleza hiyo communication lazima ndio nafaa
jambo la muhimu sana. Ndio. Kuna hili swala ambalo pendekezo ambalo Rais William Ruto amechukua hivi majuzi na ikawa imegonga vichwa vya habari kuhusiana na privatization of parastatals. Unahisi labda hii itasaidia serikali katika jitihada za kupata pesa zaidi?
Yeah. Ni kweli, jana niliona kwamba kuna hizo kampuni 11, lakini pia wako na zaidi kuliko hiyo. Na sana ni zile kampuni zenye hazina faida, ni profits, yani hazileti faida. Wakiuza hizo kampuni watapata fedha, na hiyo fedha wakiuzia watu wa nje utapata dola, na hiyo dola wanaweza tumia kulipa madeni yetu. Ni kweli, lakini swali kubwa ni kwamba ukiuza hizo kampuni, tuseme kama kuna ile niliona ni gani,
Kenya Pipeline
yenye iko na tusemaje, kwa Kiingereza kidogo, critical infrastructure, ikuwe na watu wenye wametoka nje, tuseme si wa Kenya, wataweza kufanya hiyo kurudisha hiyo kampuni kuleta faida na bila kuleta dhulumu kwa Wakenya na tusiwe na hiyo tuseme dependence na watu wa nje. Hiyo ndio shida, lakini kwa ujumla kuuza hizo kampuni zenye hazileti faida ni jambo nzuri ikifanywa vizuri na ikileta faida, ikileta pesa yenye tunaweza tumia kulipa madeni zetu na pia labda kupunguza ushuru, lakini inafaa kufanywa kwa vizuri, kwa sababu inaweza fanywa vibaya. Unaweza pata watu wanakuja kuinvest lakini hawajaleta faida kwa hiyo kampuni labda unapata wanauza hizo assets na hazileti faida. Kwa hivyo ni jambo inafaa Wakenya pia wafuatilie vizuri, waelezwe vizuri ni kwa nini hizi kampuni zinauzwa na ni faida gani zitaleta, na tusipoleta faida ni kwa nini. Kwa sababu serikali, yani sisi tulikuwa na shareholding, tulikuwa na kwa hizo kampuni. Kwa nini tunauzia wengine isipokuwa kama naleta kazi pia? Kenya shida kubwa tunayo ni kazi, kuna kazi ya kutosha. Kwa hivyo hawa wenye wananunua wanafaa kutueleza, ndio tuleta faida kweli na tulepa ushuru, lakini wananchi watapata kazi.
Lazima kuwepo na hiyo hakikisho.
Ndio.
Naam. Mwangi, tu kumalizia kwa sababu muda umekimbia zaidi. Unahisi sera gani inafaa kuwekwa na serikali ili kuhakikisha kwamba inakusanya mapato zaidi bila kumuumiza mwananchi wa kawaida?
Ni vigumu kwa nchi. Hali ya kiuchumi ya nchi ni kwamba serikali yahitaji fedha nyingi mno ili kuweza kukidhi mahitaji yake kama serikali. Ya kwanza ni kwamba serikali lazima itoe huduma kwa umma. Ya pili, serikali ina jukumu la kulipa madeni ambayo ni mengi mno. Kwa hivyo serikali haina budi ila kuokota ushuru, kutoza ushuru watu, na ukweli ni kwamba hakuna mtu ambaye apenda akitozwa ushuru zaidi, lakini serikali imejipata mahali ambapo lazima iongeze. La mno ni kwamba serikali yafaa kuongeza idadi ya wanaotoa ushuru. Ni vizuri tuelewe ya kwamba informal sector ya Kenya imewaajiri asilimia 80 ya waajiriwa wote wa nchi. Mbinu ambazo zafaa kuchukuliwa na serikali ni zile ambazo zitawawezesha kuingia katika informal sector ya nchi na kuwafanya wengi walioko katika informal sector waweze kuingia katika kikapu cha wale ambao wanatozwa ushuru na serikali. Ya pili, kama ile haitatosha, itabidi serikali iongeze matozo yake ya ushuru kwa wanaolipa, kama ambavyo imefanya kwa mwaka ambao waenda kupita. Letu ambalo twaweza omba ni kwamba mapato ya nchi yakizidi kuongezeka, ni kwamba na walipa ushuru idadi yao ikizidi kuongezeka, ya kwamba huenda serikali ikaanza, unajua Finance Act hufanywa kila mwaka. Hiyo si kusema ya kwamba kwa sababu ushuru umepanda juu sana, mwaka ujao hatuwezi kuwa na Finance Act ambayo itarudisha ushuru chini kulingana na pato la nchi limeongezeka kwa kiasi kipi. Na ni vizuri kusema ya kwamba pia rais kwa upande wake ametia bidii. Tutaona ya kwamba ajaribu awezavyo kuongeza idadi ya watakaoenda kufanya kazi nje ya nchi ya taifa la Kenya. Na ni vizuri kusema ya kwamba pesa ambazo zatokana na wanaofanya kazi nje ya nchi ni moja ambayo ni njia kuu ya nchi kujipatia sarafu za kigeni. Na ni vizuri kusema ya kwamba mwaka uliopita pato hilo lilikuwa zaidi hata ya fedha ambazo tulipata kutokana na chai. Kwa hivyo kuna yale mambo na sera ambazo serikali imeweka ya kujaribu kutafuta pesa na kuongeza pato la nchi, ili pato la nchi linavyozidi kuongezeka huenda ushuru ukaje chini. kama vile mwenzangu amesema, kile serikali yafaa kufanya haswa ni kuongeza hadhi katika kuelezea watu. Tumejipata katika hali hii. Tunatarajia kuwa katika hali hii kwa muda huu. Na tunafanya haya ili tuweze kuondokea hali ambayo tulioko. Na lile ndilo laonekana kana kwamba serikali wajivuta sana kuwaelezea watu. Na ujue ya kwamba tunasema na Kiingereza there is no vacuum. Kwa hivyo usipotuambia wengine watatueleza. Kwa hivyo usipotuambia huenda tukaelezwa yasiyo ya ukweli na ambayo pengine itatupotoza. Kwa hivyo serikali tungeiomba inabidi kuelezea wananchi wake vizuri, iwe na mikakati na sera ambazo zitafanya ujumbe kutoka kwa serikali ambao ni wa kuaminika na ukweli uwafikie watu na uwafikie kwa njia ipasavyo, ili wananchi wawe wakijua serikali yao inafanya mambo yapi ili kupunguza gharama ya maisha ambayo imekuwa juu mno, kujaribu kufanya shilingi ya Kenya ambayo imedidimia kwa dhamana iongezeke. Kwa hivyo mambo haya yote tunatarajia serikali itaweza kufanya ipasavyo.
Naam, asante sana Sam Kimani kwa mchango huo. Noel, kwa kifupi tu, chini ya dakika moja ama mbili hivi, hebu tueleze mikakati, iwapo kama kuna mikakati kama hii ambayo imewekwa na serikali ya Kenya Kwanza mwaka mmoja sasa hivi.
Ndio, ningesema kwamba kushuka kwa shilingi yetu, vile tumesema kwamba mfumuko wa bei, inflation, imechangia hiyo pia. Na tumeona kwamba ukiangalia mfumuko wa bei, kuna chakula, kuna hiyo sehemu ya chakula, kuna sehemu ya mafuta na mambo mengine. Ile ya chakula tumesema haijapanda sana. Na pia tunajua mvua imesaidia hiyo pia. Lakini hapo kwa mafuta na stima imechangia zaidi. Kwa hivyo serikali wanafaa kuangalia mafuta na stima vile wanaweza shukisha, ndio wananchi wanaweza ndio.
Naam, asante sana Noel Ikirara kwa kuchanganua na kumfahamisha Mkenya kuhusiana na mwelekeo ambapo serikali inachukua kwa sasa. Asante sana kwa mchango wako. Angalau Mkenya amepata taswira kamili kuhusiana na